Name has to be inserted. I mean, correction could be.
My lord, may I be permitted to mention one matter, my lord? This is second appeal, my lord, for admission and, my lord, condonation of delay and admission.
Milord. Milord, second appeal, Milord.
Your Honor, may I permit one mention later? Actually, petition lawyer name has been wrongly written.
Lordship, it's a habeas corpus matter for inclusion in the list.
Your Lordship, I'm mentioning for the inclusion of the matter. Criminal.
What matter? What matter?
Criminal
Criminal
appeal.
appeal are all there. It's not on
Your
the,
Lordship, bail in connection with appeal is pending there, Your Lordship.
Milord, for upgradation in the daily causes,
what?
for an FMT hearing. FMT.
Committee hearing when it is called release.
Today is it in item number 103.
Huh.
So can it be upgraded, Milord?
Criminal appeal is there, all the appeals. Huh? So it is not a criminal appeal. You are asking for its inclusion as an bail in connection with it.
The legal lordship may be permitted to mention a restoration application of a first appeal, lordship.
No.
Lordship, it was dismissed for default by the,
So you suffered that.
no, this changed out brief, lordship.
You suffered that. Call the list.
Item number 1.
Lordship, I am for the applicant.
Yes.
Lordship, as per the direction section 5 of Limitation Act application I have filed, Lordship, there was 3 days delay.
All right. Application for condonation of delay has been filed. Copy of the application be served upon opposite party number 1 to 7 through registered speed post with acknowledgement due. Upon opposite party number 8 through registered speed post before additional people, huh? Matter will appear 4 weeks since. Next. Yes, next matter. Necessary corrections be made in the court. Next.
Item number 3.
Next.
Item number 4.
देखे करो. Next.
Item number 5.
Same.
Lord, I am for this.
Been 7.
But I am for the petitioner, my lord. These matters were disposed of matters, my lord. I am also in doubt, my lord, why these matters has appeared in the list.
All right, report of additional Director General and Inspector General of Police, North Bengal Range. Peruse report of so and so. Steps have been taken as per order dated 30/11/2023, passed by a coordinate bench of this court. Additional Director General and Inspector General of Police has taken steps. Accordingly, proceeding is closed.
Grateful.
Next.
For the petition of your lordship. This is a matter of NDPS Act, section 2AC and 22C of the NDPS Act, your lordship. 667 days in custody, your lordship. Delay in trial. 5,000 bottles of cough syrup.
What is the stage of the proceeding?
Charge sheet filed, your lordship.
Lordship, a commercial quantity.
What is the stage of the proceeding?
Stage of the trial is, lordship.
There was a report directed to be filed.
Lordship.
Charge framed on 3/4/2023. Next date is on, was on 22nd/4/2024 for execution of WPA. There is WPA pending against another person.
Then who is that person? What, do you have a report?
But,
You're supposed to
they have
file it.
mentioned it.
You have to file a report, that is the
Report.
petition.
Lordship, the report is with the deputy registrar. They have deposited. If possible, Lordship, we can bring it.
October,
First of all.
next.
Lordship, I'm for the petition. Lordship, I'm for the petition and report was also for the first of all, Lordship. My submission is that Lordship, he is in custody. Another two active persons are in bail, Lordship. Evidence has already started and half of the witnesses have been completed, Lordship. Custody trial is not required, Lordship, as it's under any conditions.
Where is the, no medical examination was done.
Lordship, this is the previous report and the present report has been sent to deputy registrar. I think it has been placed before.
So there is, see the present report. You should have a copy of the report. The present report is
They
given to
haven't-
the
they
deputy
just
registrar.
said that they
Yes,
deposited.
then what is the use of the lawyer for the state? Where is the report?
UTP has been sent to North Bengal Medical College Hospital. There is 14. The UTP was placed before the North Bengal Medical, but
Then where is the report of the doctor?
previous report we have. This report we don't have.
Then what is the use? What is being said?
Possible, Lordship, I'll just,
For what? What possible? You will get the report by today?
Lordship. We'll just communicate if the report.
Not today. Medical report be positively placed on the agenda.
Reported. May I place the previous report, Lordship?
1 second. আগেরটা দাও। এটা কি দিলে? হয়ে গেল তো এটা।
Previous report, Lordship.
হুম।
আচ্ছা।
Where did the lawyer is not?
কোন নিতে যাচ্ছে?
উনিও না, he just doesn't operate to it. Yes, let us see
The previous report, Lordship. দিন না। Nine number. Nine number. Nine.
you are showing what you are showing the previous report. Item number 9.
It's 9.
You said that there is a report in item 8.
8 report is coming, Lordship. This is item 9 report, Lordship, previous report.
What will we do with the previous report? You have asked for the report
Lordship,
now. Give the report. Next.
Today's date has been fixed for submitting a report regarding the status, your lordships.
My lord, 1 year, 9 months custody. Last date I stated that none of the witness has been examined. They stated 5 witnesses. Status was called.
But co-accused earlier, just yesterday granted bail on the same.
Report is placed on record. No Prosecution witness has been examined till date. Petitioner is in custody for 1 year, 9 months, though narcotics above commercial quantity. That is, what is recovered
25 bottles from him,
altogether?
50 bottles.
50 bottles of fencyl syrup was recovered from petitioner and co-accused. We note trial has not progressed with adequate expedition. This has infracted the fundamental right to speedy justice of the petitioner. He is entitled to bail on the ground of delay.
Very good.
Bail period is not restricted by features of section 36. Bail prayer on ground of delay. Ravi Prakash. Next.
Yes, sir. I'm for the building, Your Lordship.
My lord, a report was called for whether witness evidence has started or not. Charge was spent on 3rd of April 2024. And the next date was fixed on 13th of May 2024 for evidence, but there was no evidence. Witnesses were not there. It is fixed on 19th of June 2020.
My lord, there is lapse of petitioner is in custody since 457 days. And charge sheet also submitted on July 29th, 2023. There is a prolonged gap, Lordship. There is unnecessary
What
delay
is the quantity of narcotics?
300 grams of brown sugar.
Petitioner
from the
is in-
joint position of the.
Petitioner is in custody for more than 457 days. He submits. There is no progress in trial. He accordingly prays for bail. Learned lawyer for the state submits report. From the report, we note. What you are submitting?
This is the order sheet, my lord.
We are asking.
My
for
lord, after a lapse of
report.
9
Please,
days.
can you keep quiet? We'll call upon you if it is necessary. We are calling for a report. A report is necessary. This is the order sheet is not a report. Learned lawyer for state submits. Charge has been framed, but no witnesses have been examined till date. We have considered the materials on record, though 300 grams of brown sugar, that is heroin, was recovered. Petitioner is in custody for a considerable period of time. Prosecution has not examined any witness. How many witnesses are there in the charge sheet?
There is 12 witnesses.
Petitioner is not responsible for the delay. Prosecution proposes to examine 12 witnesses. There is no possibility of trial concluding in near future. Under such circumstances, fundamental right to speedy justice of the petitioner has been infracted and he is entitled to bail on the spot. Bail prayer on the ground of delay is not fettered by restrictions under 37 of NDPS Act. Ravi Prakash, allowed. Next.
Your Lordship. Short passover on the way, report on the way. But the direction give me to submit a report and jailer said it
Passed
10
over.
minutes required.
Passed over. Next.
My lords, I'm for the petitioner. My lords, on the last date, you had called for a status report from the state. My lords, I've also made a list of dates for your petition. My lords, 2 years, 8 months in custody, 22 bottles of cough syrup. Only one witness has been examined till date.
Petitioner is in custody for 2 years, 8 months. He prays for bail on the ground of delay in trial. State has submitted report. From the report, it appears charge was framed in May 2022. Till date, two witnesses have been examined.
My lords, only one and second is partially examined.
Why partially examined?
My lords, evidence in chief has started and it was deferred by the prosecution.
Then how on the next date you are fixing 21-5 others?
Lordship, the defense declined to cross-examine The report is here.
List of dates will not be.
What you see is, on 17/10/2023, PW1 ASI.
No, that we have seen. What about CSW two?
CSW 1, 2, and 3 are fixed on 21st/5/2024.
My lord.
1, 2, and 3 is not there.
Uh,
2 and 3,
PW1 has been completed.
CSW two on 2 dates.
CSW1, Lordship.
So whoever, the second witness,
Lordship.
what happened to the second witness?
Next date is, he was present but did not,
What is the date? Tell us.
the date is there, Lordship.
My lords,
19/2.
my lords, page 44. My lords, at page 44 of my petition, I've annexed the examination in chief as well, my lords. If my lords may see, it was referred on the prayer of the prosecution. And my lord, thereafter, 2 dates have passed. Even on that day, no witness was present. After 19th February 2024, on March 14th and 18th April, 2 dates were fixed. On those days, witnesses were not present, my lords. Out of total of 8 dates, 1, 2, 3, 4, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 14. My lords, after total of 13 days since the framing of charge, only on 3 days witnesses were present, my lords.
No, it was 19/2 was examined.
My lords, at page 44, I've
Have you seen the petition? Have you seen the
The dates.
order sheets?
Lordship.
Then what happened on 18/3, 18/4?
my lords, no. My lords, at page 38. No, it's not. I did not. My lords, at page 40, that is. Oh, that's not. there.
Neither
It's
the
not there.
petitioner nor the state lawyer go through the petition.
My lord, at page, my lord.
Please do not lecture us.
I'm sorry, my lords. Apologize.
You will first go through your papers and thereafter submit.
My
Lordship,
apologies.
after 6/4 is 24. They are filed.
Please see page 38, 19/2/2024. Date is fixed on 14/3
Yes.
and the 14/3 order is not,
My lord,
Not
was,
my lord, it's at page 39, my
that we have
lords.
seen. That's only the bail order.
At 40, my,
That's only the bail order.
Lordship, 14/3 is no SR received.
And then 18/4. What happens on 18/4? Election was.
19,
Election, 18 and 19, nothing happened.
So we are giving you opportunity to lead 3 witnesses on 20th. Let us see. For more than 2 years and 8 months, supplementary report is placed on record. From the report, we note 1 witness has been examined. PW2, examination of PW2 was fixed on 19/2/2024. As the petitioner preferred a bail application and the case diary was before this court, witness, though present, could not be examined. Thereafter, on 14/3/2024, witness was not present and date was fixed on 18/5/2024. On that day, no proceeding, on that day, parliamentary elections were held and were scheduled and no proceedings, and the matter was adjourned till 21st May 2024. To test the bona fides of the prosecution, we adjourn the hearing of this application till 22nd May 2024. Prosecution shall take steps to examine witnesses on the adjourned date. Further report be filed.
Grateful, my lords.
Now you see the quality of your report. It's not even worth the paper. And we have a lawyer for the state who is not even looking through the order sheet. If you had looked through the order sheet and seen the report, you would have told us, please don't look into this report. Right?
Apologies, Lord.
Next.
Okay.
Not voting, I am for the applicant, my lord. But the matter was adjourned due to filing the affidavit of service, my lord. This is. I don't know, one statement.
After service is complete. After service placed on record. Let us see.
Part in which why she was, my lord.
How long you were in custody?
The next for more than 4 months.
Hmm?
More than 4 months, my lord. It's 4 months and 14 days.
Oh, that 9 month pregnancy.
Yes, my
Oh.
lord, that matter.
Petitioner submits that is 4 months, for more, he
And there was a, like, as per allegation, the victim was hit by stick, subsequently taken to the hospital where he succumbed to the, yeah. Now, as per these petitioners are concerned, eyewitnesses stating that they were only present in the spot in page number 21, 161.
Yes, what are the statements?
My lord, there was a fight on a particular subject, my lord.
What is the particular subject?
My lord, they had some discussion, my lord. That is the version. They had some discussion, my lord. Altercation took place, and thereafter fight happened, my lord. This petitioner, my lord, the deceased person was brutally, my lord, he was,
Did these persons participate in the assault?
yes, my lord, the 164 says that. my lord.
Let us,
161 of the eyewitness in page number 21 is stating that he was, these two petitioners were already present out there.
let us see what 164 statement is.
My lord, two 164 statement,
Name
one
of
is
the
in Nepali.
eyewitnesses, the name of these witnesses, 161,
161 is Shumiran Chetri.
Shamiran.
Shumiran Chetri.
All right. Name is Dipankar Rai.
Yes.
Yes, my lord.
Within 161 of the.
Dipankar Rai.
Yes.
And Shunandan, that is
Yes.
Vishwa's son. Vishwaguru's son. Who is the statement? Petitioners submit there was an altercation between petitioner and one Uday Mukhia, the deceased, full stop. Subsequently, son of petitioner number one brought a, subsequently, Uday Mukhia proceeded to his hotel, full stop. There, son of petitioner number one brought a lathi and one Dipankar Rai assaulted the victim on the head. Full stop. Petitioners were present at the spot. Full stop. Keeping in mind the extent of complicity of petitioners in the crime, and as none of them had assaulted the deceased, assaulted or exhorted the assault, full stop, we are inclined to enlarge them on bail.
Or stranger condition.
Meet officer in charge once in a week. CJ. Next. Laksam,
Yes, my lord.
where is the statement?
Statement is here, my lord.
Lordship, I didn't get the CD. It's a new filing.
Tomorrow?
Monday.
Huh?
Monday.
Monday. Monday. First over.
Number 8.
Eight, not today. Ask them to produce. Next.
Number 12.
12.
I have already annexed a copy which I have obtained through RTI.
My lord, so far my IO is concerned and the report has been filed by the jail authority, totally different, as because your lordships, after peruse the report. Huge quantity substance recovered from his exclusive position. And thereafter, when he filed this application, he admitted, and due to high sugar that may happen, but they are taking that advantage, your lordship.
Not only.
And this, in our, all our
Page number
good.
13, I have filed application which I have got through RTI.
All right. Keep it in your pocket.
At present also he is lying at hospital.
Yes, your lordship.
He is not in hospital. He is not in hospital.
Now he's, after filing this application, became unconscious and had been to the hospital.
It's
But
continuously has been
here is a, earlier occasion was doing same play, your lordships, and thereafter he completely fit and fine.
Not for a single day.
Huge
he was-
quantity, lordships.
Not for a single day, he was out of hospital after he has been arrested. Still presently.
And here is a medical
that-
facilities, your lordships.
2 times sent for NDPS. I have given the list. If my lord kindly come to page number 13, to RTI I have obtained all these things.
Lordships, I have already filed the seizure list, lordships, exclusive position. And doing this business
Several diseases.
in grocery shop, your
Neuro
lordship.
problem, seizure disorder, chronic kidney disease,
Here, medical facilities
HHG,
here.
several things, man. And she will, he's totally in a
When did
condition,
it?
he will die if he is not taken proper care of. Only pain.
Lordship, this is not the ground, it's because lordship, they are taking that advantage. Under the exclusive position and grocery shops, the contaminant article 6 seized, your lordship, 688 liters, 14,500 tablets, 70,280 tablets
How many days in custody?
on very
109
recent
days.
days.
109 days.
109. 109.
More than 3 months. 3 months, 2 weeks.
Very recent case, your lordship.
More than 3 months, 2 weeks.
Case was instituted
At least-
12
the
January
in-
24,
At
your
least
lordship.
the interim bail will get him properly treated, will surrender.
Lordship, here
You are
also
being
there is a
treated in hospital, no difficulty.
And my lord, there is another ground, there is a violation of 42A.
Very good. Petitioner contends he is suffering from medical ailments. And he prays for bail on the ground of poor health. Medical report is placed on record. From the medical report, it appears petitioner is suffering from diabetes, hypothyroidism, etc. he was treated in hospital and was released and was released and was discharged in March 2024. During the pendency of the bail petition, he has again been admitted to hospital and given necessary care. In light of the report, we are of the opinion prompt and immediate medical attention has been given to the petitioner. Petitioner under such allegations, petitioner is involved in dealing in narcotics above commercial quantity. A large volume of narcotics, that is 5,000 bottles of cough syrup containing codeine phosphate
14,500. The tablets
and 14,500 tablets containing what? Spasmoproximon?
nitrosamine 10, Lordship 14,000 and 17,208 winspasm prot. And 688 liters
Ajay.
cough syrup.
240 bottles of cough syrup containing codeine phosphate? No. Ajay. 244, 688 liters of cough syrup containing codeine phosphate, comma, 145 packets of nitrosum and 120 packets of Wins Spasmo Forte tablet, one. Ajay. And the large volume of various tablets containing narcotic substance were recovered. Petitioner does not have valid license to deal in medicines. He was unable to give explanation with regard to illicit possession of medicine containing narcotics. In light of the aforesaid circumstances, we are not inclined to grant bail. Circumstance and restriction on 37, we are not inclined to grant bail. We direct the correctional home authorities to render medical attention to the petitioner and arrange, and in the event of emergency, to arrange for his institutional treatment. Full stop. If there is any deterioration, come to us. If there is any further deterioration, come to us. As of now, what we see is he is getting hypoglycemic and therefore. Yes, we are RTI is got to you. We have seen the medical officer's report. Because of the blood. Yes. Next.
Oh, my lord, the petitioner has surrendered the last.
Surrender
Yes,
not
my lord.
pressed.
Surrendered.
Petitioner has surrendered before the trial court. Accordingly, prayer for ancillary bail is not pressed. In the event petitioner prays for bail, the same shall be considered independently and in accordance with law. Investigating officer is present.
No, my lord, he is not present, but he has sent me one letter saying that he is presently in Hooghly doing my lord,
Alright.
Lok Sabha election.
Investigating officer has submitted reports stating that he has been posted for law and order duty in connection with parliamentary elections. His presence, his absence is excused. Good stop. We are petitioner has তারপরে এই order. Next. Yes.
Wait to statement, my lord.
Petitioner is an Indian national. He has been falsely implicated. It is contended he has been falsely implicated on the statement of co-accused. He prays for ancillary pay. Run a lawyer for the state produces the case diary. We have considered the materials on record. Statement materials on record. Petitioner is an Indian national. Keeping in mind the extent of his complicity in the crime, we are inclined to grant answer. Next. Mr. Ganguly appear. This is a jail appeal. Mr. Ganguly is requested to appear on behalf of the appellant. Secretary High Court Legal Services Committee shall regularize his appointment. He shall take necessary steps. Matter will appear. Liberty to mention. Next.
In this case, for the petitioner because also the owner of a commercial vehicle, only so. The petitioner because also the owner of a commercial vehicle. Owner of the vehicle from which the recovery was made. The car of recovery was made from the driver and as well as the authorization from the driver.
No, even if there is an authorization, that will not serve the purpose. He has a liability.
Co-accused, one of the co-accused granted.
Not on the same footing. He is the owner of the vehicle, Lordship.
Then you are the owner of the vehicle.
Not kindly come to the civil list, the authorization recovered.
Where is the authorization?
Page 99 of the civil report.
Huh? Where is your authorization?
The authorization they have in their possession.
They have
They
it.
have started. They have seen.
This is the authorization.
Authorization in favor of whom?
The drive.
Then authorization in driver is nothing.
Nothing. His driver. He's the owner. He.
Petitioner is a.
Of the position. I don't have the master position.
No.
The Bolero pickup van.
Commercial vehicle.
All right.
He is already.
Petitioner is the owner of a commercial vehicle.
5 kg.
Submits.
5 kg.
He was unaware of the narcotics carried in the vehicle by his driver. He prays for ancillary bail. Learned lawyer for the state opposes the prayer. We have considered the materials on record. We have also examined the authorization in favor of the driver, that is Maloy Shorkar. The letter of authority merely the letter merely authorizes Maloy Shorkar to drive the vehicle. Nothing is placed on record that the vehicle had been let out to a third party. In view of the aforesaid circumstances, petitioner had constructive and conscious possession of the vehicle which was used to transport narcotics. Under such circumstances, we are not inclined to grant ancillary.
Section 5 is, they are the electoral.
Restored. Next.
Milord, I am for the petitioner, Milord. This petitioner is in custody for almost 4 years, Milord. And 80 witnesses is cited in the charge sheet, Milord. Out of them, 6 has been examined, Milord. And this petitioner do not have any antecedent, Milord.
Yes, you file a report.
Yes, I'm filing it. Your Lordship.
Give me a copy of that.
Given a report to him. Why, sir, when you are making a report, at least one copy for them should be there, isn't it? These practices need to be ingrained in a high court bench. What is the use? Your problem, sir, is paragraph 11. Paragraph 11 is your problem, sir. Zakir Sheikh was turned down in November,
Milord.
in December. So there's no change in circumstance.
Milord, long detention, Milord. I've got.
From December, what is the long detention today?
No, he's in the custody since 2020, Milord, almost 4 years.
Zakir Sheikh is in custody from when?
There is a judgment given by your lordship only that on the ground of long.
In that judgment, A, bail applications do not have any binding precedent until and unless they are in the same case. 1. 2, we have no dispute over the fact that long detention is a ground to consider bail prayer notwithstanding restrictions under 43D5.
And
however, please let us finish. However, a coordinate bench in respect of a co-accused has turned down the bail prayer in December. Since then, 5 months have lapsed. How can we take a decision in favor of you, saying that there is inordinate delay, therefore you have to be enlarged on bail? In the event that were so, then the coordinate bench would have enlarged the other person on bail. Now, if you can distinguish yourself from Zakir Sheikh, you are welcome. If not, then we cannot. How long will you take to finish the trial?
Actually, on the last occasion, I had submitted there are 5 accused persons, and out of 5 accused persons, 3 accused persons are also facing trial before a special court in NIA Patna on similar charges, and the trial could not be expedited for want of their production.
Is Mustaq facing trial in Patna?
3 of them.
Is Mustaq Zakir?
No, he's not.
Zakir is facing.
And Zakir and Mustaq are not facing. Other 3 accused persons.
Other 3 are facing.
And on the last, trial could not be expedited for want of their production.
Why?
And on the last, because they could not be produced, and as because authorized persons were not appointed at Siliguri court, so they could not be produced through video linkage also. On the last occasion, this honorable court was pleased to direct the CPC High Court to appoint an authorized person at Siliguri. Thereafter, authorized persons was appointed. Accused are being produced through video linkage. Charges have been framed. 6 of the accused, 6 witnesses have been examined. And other There were eight
So-
expert
so-
witnesses,
so-
they have been exempted, and then expert
So-
report had already been, so altogether, 15 witnesses have been examined.
15 witnesses have been. That you have not stated in your.
I have stated.
There are just 6 witnesses, my lord.
Plus, we have exempted the 8 witnesses, expert.
So what, how many witnesses you want to examine?
There are altogether 50 PWs have been cited as witness, but will be pruning the list, will not be examining the all witnesses.
How many witnesses you will?
I maybe 20, 30, 35 maybe, I cannot say at this moment. But
Within what time frame can you conclude the trial?
it may take about, say, 8-10 minutes, about a year. Because on each and every day, we are producing the PWs, we are examining them.
We are-
While it is expedited.
We are giving you 18 months to complete the trial.
Milo.
My lord, no antecedent of this petitioner, my lord,
Your
and he was
pa-
not named in
your
FIR
co-ac-
also, my lord.
Your co-accused have antecedents. This is the case of. conspiracy.
Allegation against this petitioner is, my lord, that he had transferred some money in the account of this, one of the accused, my lord, Gola Murtuza on the, my lord. He was not directly, and no seizure was made from this petitioner, my lord.
Same thing as Zakir. If Zakir was considered allowed, we would have taken a favorable view, but we can't take a different view. Appellant is in custody for 4 years.
Almost 4 years, not.
Almost 4 years. He submits there is inordinate delay in trial. Only 6 witnesses have been examined. Prosecution proposes to examine prosecution proposes to examine over 80 witnesses. Accordingly, no high value FICN was recovered from his possession. His complicity is based on legally untenable evidence. Hence, he prays for bail. Learned lawyer for NIA submit. Petitioner is a member of a gang, terrorist gang, which was dealing in high value counterfeit currency and thereby threatening economic security of the nation. Petitioner had telephonic conversations with co-accused, telephonic and monetary transaction with co-accused, large volume of high value counterfeit notes of over rupees 4 lakh was recovered from Ghulam Murtaza. Full stop. Ghulam Murtaza, some of the accused are facing facing trial on similar charges in Patna. As a result, there was delay. Presently, they are appearing through video linkage and witnesses have been examined. Prosecution assures this court that they will streamline the list of witnesses and conclude trial within 18 months, subject to cooperation by defense and systemic delays. We have considered the rival submissions. Bail prayer of co-accused Jakir Sheikh was turned down by a coordinate bench in December 2023. Tarpore prosecution assures. We have considered the rival submissions of the parties. It is true petitioner is in custody for more than 4 years. Delay, however, delay in the matter
Not more than.
is
almost-
about 4 years.
almost.
Delay in the matter, however, is not due to recalcitrance of prosecution. Co-accused are facing trial on similar charges. In Patna. Due to, as a result, trial could not commence. Presently, trial has commenced. Presently, co-accused have appeared through video linkage and trial has commenced. Full stop. There are material, prosecution relies on telephonic conversations and monetary transaction between petitioner and co-accused, from whom a large volume of co-accused Murtaja, Ghulam Murtaja, from whom large volume of FICNs were recovered. High value FICNs were recovered.
May I make one thing? When the principal accused was arrested at Bihar Mode and this high quality FICN was recovered, his statement under section 108 Customs Act was recorded, in which he categorically
Unreliable.
stated that he has come to deliver.
Unreliable. If you are founding your case on that 108 statement, we will say it's a very weak piece of evidence. So that conspiracy charge, let us see that we are not making any comment. We can examine the matter after a year. If you, after 18 months, if you, under such circumstances, we are of the opinion. And a bail prayer of co-accused Zakir Sheikh was turned down in December 2023. Under such circumstances, we are of the opinion petitioner has failed to make out a case either on merits or on the score of delay at present. We direct the trial court to proceed with the trial with utmost expedition in light of and to conclude the same, preferably within 18 months from the next date fixed before the court, in light of the assurance given by the prosecutor. Parties shall cooperate with the trial court and communicate this order for due compliance. Right? After that, we can examine again if they do not adequately proceed. Okay.
May I proceed, my lord?
Yeah.
Lordship, this is an appeal by SSB against the order passed by the learned single judge, setting aside the disciplinary proceedings. My lord, the impugned order proceeded on the line that
Cross-examination
was not. My lord, before going to that, my lord, if I am permitted to draw your lordship.
Should we remand it before the
My
first
lord,
court reconsideration again?
No, my
on
lord.
all points.
My lord, 175(8)(a) is not applicable in this case. My lord, if your lordship has the SSB Act, kindly lordship comes to 175(8)(a). My lord, your lordship is there. Save in the case of a prisoner of war who is still absent. So this does not apply to this delinquent.
No.
So 175(8)(b) in other cases. Now, my lord, kindly comes to the stay application page.
Please read out what is there.
Lordship, 178(a)(b), my lord. In other cases, before giving opinion against any person subject to the act, the court shall afford that person an opportunity to know all that has been stated against him, cross-examine any witness who has given evidence against him, and make a statement and call witness in his defense. Now, my lord, we have produced the entire court of inquiry record. Now, 175(8) pertains to court of inquiry. My lord, there are one very significant document signed by the delinquent who has given a declaration that the provisions of 175(8)(b) has been religiously followed.
Even if it is given, but the records show that it has.
Yes, he has cross-examined the witnesses. He has given defense witness.
In the course of
In the court of inquiry.
Mr. Dev?
Lord, there are three stages: court of inquiry, record of evidence, then general forces court. in every stage, there is a consequence. So the procedure prescribed for court of inquiry, the record of evidence, and subsequently GFC is not a mere procedure.
No.
Since there is a consequence, after the court of inquiry, the commanding officer can decide to discharge. After ROE, again, the higher authority can decide to discharge. So mere not examining or denying an opportunity of cross-examination has consequences. Therefore, it cannot be treated as substantive violation.
According to you.
In ROE, COI is not a part of formal investigation. In ROE, the records will reveal.
Let us help you. Is it your case that the cross-examination was denied in the court of inquiry?
No, in the ROE. In the ROE.
Record of evidence.
Yes, the most crucial witnesses who were deposed against me.
You were not permitted to.
Not permitted. I was asked to send questionnaires. That you send questionnaires to which they will answer. Those questionnaires never received them. And that is borne out from records. Their ROE records will speak for it.
In the answer to that
Now,
is, if
Once
a-
again,
Now,
so
even more clinching.
Your case is, it is not the stage of court of inquiry, but at the stage of recording of evidence, on the basis of which you are found guilty or not guilty.
Yes, the charges were framed.
So let us understand
Yes.
this. What is the scheme? The court of inquiry is like a preliminary.
Preliminary inquiry.
After the court of inquiry,
There will be a charge sheet framed.
Do you have a chart as to how it
Yes,
flows in the
yes.
section?
No, we
But
don't have a
it's just
chart,
like
but
that.
we can show it from the rules.
Malad is from the rules, court of inquiry will a fact-finding committee. Thereafter, whatever fact is found by the court of inquiry will
Goes to the
commanding officer.
commanding officer.
He will then-
Commanding officer authorizes or sets up a general force code.
My lord, he will frame a charge.
He will
Correct.
frame
He
a charge.
frames a charge on the basis of court of inquiry.
Court of inquiry.
Court of inquiry.
And then the man gets the opportunity. Then the man is tried before the general force.
No, my lord, record of evidence.
Recording of evidence. On the basis of those charges framed.
Record of evidence is before whom?
Before the
Before the recording
officer appointed by the
to be
commanding
appointed by the
So the recording of evidence takes place.
Right.
After the evidence is recorded,
it again comes back to the commanding officer.
it comes back to
The
the
commanding officer may, as Mr. Ghosh said rightly, he may dismiss the charge. He may again say that further ROE is required, or he may simply send it before the convening officer to convene a general force court.
And now before the general force court, again evidence is recorded.
No, my lord.
Or that recording.
That
of-
record will go forward.
That recording of that evidence.
That evidence.
The ROE evidence.
ROE evidence.
That ROE evidence is considered before the general force
Force
court.
court.
And before the general force court, it is only a matter of arguments on
No,
that
no, my lord.
evidence.
He can cross-examine once again. He can bring in defense witness. He can even question the jurisdiction of the force court.
Correct. Now, jurisdiction, etc. is, but with regard to the
No, no,
evidence,
he is free to cross-examine again.
with regard to the ROE, is the evidence can be subjected to cross-examination? in the-
Yes.
Yes,
Yes,
yes, my lord.
I can.
And my
But-
lord,
But
before,
since ROE has a consequence, any violation of the ROE will render anything that has happened subsequently null and void. Because ROE has a consequence, because on the basis of those evidence, the commanding officer or his higher authority has a discretion to exercise. Here he has exercised the discretion. That is, you convene a GFC.
no, my lord.
That discretion has been exercised on the basis of materials which were absolutely incomplete. That exercise of discretion was not proper. And more clinching, when he convened the GFC, he convened the GFC on the basis of a
But
charge sheet,
you-
which was absolutely new. On the basis of new charges. Unknown to law, I
my
can
lord-
demonstrate from the rules that
my
there is a
lord-
provision of reframing of
Yes,
charge sheet.
that
It is
was-
there. But how reframing has to be done and who can do it under what circumstances, the rule is very clear. There's nothing to demonstrate that he has reframed it in accordance with 162(7). That is the only provision for reframing. There's nothing to demonstrate he have exercised his powers under, and that power has to be exercised by the Director General. The
No,
rule says
no,
so.
my lord, it is rule 62, where the convening officer has the power to reframe the charge before GFC starts.
Let's examine the provisions one by one as Mr. Majumdar wants to take your lordships.
No, the thing is that you must first argue, because today the arguments.
Yes, I am ready to argue.
You don't understand what we are saying.
Millard is.
We are saying that who should have the right of audience first,
Yes.
because Here we are faced with an order where the learned judge, trial judge has only considered non-examination of witness or failure to cross-examine witnesses before ROE.
Right.
No,
Now,
my lord, that is court of inquiry. 175 is court of inquiry.
what is the judgment?
Lordship is
before us?
infraction of 175 8A. Page 16, my lord.
Yes. Sufficient to say as denial of cross-examination. Oh, gross 175A, it should be read as 8B.
Yes, A or B.
A or B. So
Yes.
it is B.
It is B.
So
And-
according to you, this was not at all the case. Court of inquiry, he had
Yes,
opportunity
my
to
lord.
cross.
178, 175,
My lord,
8A
kindly comes to
is
page
still
93.
violated because both the examination and recording of the statements has happened in my absence in the court of inquiry.
You had the opportunity to cross-examine.
That's right.
Then
But the statute says that it should be done in my presence. I should remain associated with the proceeding. That's what 8A says. Such person may be associated throughout the inquiry and be given full opportunity of making any statement or giving any evidence. He may wish.
where you were reading?
175, 8A.
8A is not applicable.
No, I was never a prisoner of war who was absent. I was tried as an officer. I was a deputy
there is B.
commander.
Such person may be associated throughout the and may give full opportunity of making any statement or giving any, and he may wish to give and of cross-examination. Now, you had opportunity to cross-examine.
Yes, I.
And you also were given an opportunity to lead evidence.
Yes.
Then it effectively it is.
My lord, kindly takes page
Over.
93 of the stay application. The delinquent has himself written down that 175 8B has been religiously followed in court of inquiry.
But what we are concerned is, Mr. Majumdar, there are other points on which he has agitated.
But my lord, when the first order was passed by the honorable writ court, the writ court only zeroed down the of the writ, scope of the writ.
No, the single judge appears to have only held that on this point, this is good enough, so we are not going into the other issues.
Yes. That's
No, my
Now,
lord,
what we can do is we can go into the other issues at this stage, at the appellate stage, and consider whether it
No,
is
my lord,
lawful or
Milord,
not.
I am saying Milord kindly does that because of the reason.
Sir, first, we are not agreeing with the single judge on violation of 173 8A or B.
Milord, but there are other points also.
So that is what we are saying.
Yes.
If these are other points, then you need to address us one by one with regard to each of the violations that you indicate.
I'm ready, Milord. I can start immediately. No
Have
problem.
you filed any opposition to the,
I have filed my opposition to the stay application.
your writ petition is already there.
In the writ petition, they have filed their opposition. My reply was also supplementary.
In the writ
affidavit was-
petition also,
Yes,
they have
yes,
filed an
yes,
opposition. So we can consider those
Yes,
aspects.
yes,
Please enumerate the violations one by one. The first
yes.
violation 173 8. We are not really very convinced. You had
Yes.
effective opportunity to cross-examination and you have also given a declaration that there was no violation.
Yes. Now, Milord kindly takes page 326 of the stay application. This is Milord part of the records. Milord starts from 323 of the stay application. P23, the second in command, that is the recording officer of ROE, submits the recording of evidence.
Can you
records.
give us a short note with regard to what are the violations?
Milord, it's briefly stated in my affidavit in opposition
Where,
by referring the rules
where is,
in my affidavit in opposition to the stay application.
absolutely not. Yes. Page,
Milord, kindly takes, from para 9 onwards, till para 8, I have highlighted the violations with regard to court of inquiry. There are other violations also. Para 9 onwards, I have stated the violations as regards the recording of evidence stage. Twelve and 13 is what, Millard, I am arguing right now. Paragraph 12 and
Let us
13.
one by one, what you have to, we are not at all aware what you have stated.
Yes,
Can
Millard,
you indicate to us?
let me, Millard, complete with the recording of evidence stage first. Because those violations are most clinching. Millard, I'll go by the strongest points first.
All right, let us see what is your
Yes.
strongest one.
323,
Paragraph.
Millard, 12 and 13
12
of the
and, now
affidavit.
place 12 and 13.
Yes. 323, Millard, is the records of recording of evidence which was forwarded to the commandant. Now, Millard, kindly takes 326, page 326.
What is the violation? Can you
Yes.
read out?
Millard,
What is
Millard takes rule 51.
to tell us what is the violation?
The rule 2, the witnesses shall give their evidence in the presence of the accused, and the accused shall have the right to cross-examine all witnesses who give evidence against him, provided that where a statement of any witness of a court of inquiry is available, examination of such a witness may be dispensed with. Millard marks this, and the original copy of the said statement may be taken on record, and a copy thereof shall be given to the accused.
Correct.
And he shall have the right to cross-examine if he was not afforded an opportunity to cross-examine the witness at the court of inquiry. Now,
This is rule 2.
Rule 51(2).
Right.
Now, here, they have not dispensed with the cross-examination. Had they dispensed with, this proviso would have been applicable that we are adopting the entire records of COI, no cross-examination further. This they have not done. They preferred to afford me an opportunity to cross-examination that will borne out from
First and
326.
foremost, did they adopt the evidence of the court of inquiry?
Yes,
They adopted.
they adopted.
And then they again gave you an opportunity to cross-examine.
Opportunity to cross-examine.
Correct.
Now, whether they have adopted the COI proceedings in entirety, the record, the certificate is silent on that. Now, 326, Millard takes the last paragraph. 326, last paragraph. This is part of the certificate under 51, which the recording officer is supposed to issue under the rules.
Yes.
It is certified that for cross-examination, a questionnaire was sent by the accused Sri Jayanta Pathak to PW1, PW2, PW4 through recording officer, but the same were neither received by the PW1, PW2, PW4 nor replied. The questionnaire sent to the PWs are attached with the record of evidence as exhibit so and so. The above statement, next page, the above statement of the witnesses have been read over and explained to him in the language that is English, he understands well and sign it as correct. Now, Millard, after the recording of evidence is complete, the next stage is Rule 54. Millard, kindly have a look at Rule 54 once. Once the ROE is complete, it has to be sent to the commanding officer. That is clause 1. Clause 2 is the commanding officer, what are the options available before him after he receives the records of ROE? Remand the case for recording additional evidence, dismiss the charge provided where disciplinary action has been initiated against an officer on a reference from a superior authority. Charge shall not be dismissed without reference to such an authority. Rehear the charge and award one of the summary punishments. Try the accused summarily under section 56. Remand the case for summary disposal by the competent authority in case of an officer or a subordinate officer, or apply to a competent authority or authority to convene a court for the trial of the accused. Now he has exercised a discretion in invoking 54(2)(6). He has called for convening of a court for trial of the accused. Now, Millard kindly comes at Millard page 222 of the stay application. The convening order. Convening order for the recording of evidence. Page 222. In pursuance of sector headquarters so and so, Sri Sanjay Kumar Gupta is hereby detailed as recording officer to conduct record of evidence under Rule 51 against Jayanta Kumar Pathak as per charges mentioned in Appendix B enclosed with this order. What are the charges? Millard kindly turns over. 223, Section 49, civil offense. Millard kindly marks this. This is very important for me. Civil offense punishable under so and so under Prevention of Corruption Act. Section 49, civil offense punishable under so and so of the Prevention of Corruption Act. On the basis of these charges, the entire recording of evidence took place. Now, Millard, comes to 230. Now, Millard kindly takes page 230 once.
Hmm.
230 is subsequent to ROE, when the GFC is being constituted, this is the necessary office memorandum. This discloses that there shall be a GFC which has to be convened. The defending officer, the prosecuting officer. 231 is the order for assembly on the General Force Court, and 232 will be very surprising that the GFC is constituted to try me on a set of charges which is completely different. A higher provision, a higher punishment is sought to be invoked. 49 civil offense, civil punishment, civil offense goes, they now invokes 34B. 232. When this was served upon me, this writ petition was preferred. So the cause of action for this writ petition was not the GFC, was this alteration of charge, on the basis of which Justice Sarkar, hearing for the first time, granted me a stay of the GFC proceedings. Subsequently, application was moved before one of the honorable single judges, saying that I am trying to influence some witnesses. His lordship deemed it fit that the GFC should go on, but you should not pronounce the punishment or give any effect to the punishment. The matter came up for final disposal. The learned honorable single judge, hearing it finally, held that since GFC has been concluded, pronounce the punishment over, you go for appeal. Against that order, we preferred an appeal before the Honorable Division Bench. Honorable Division Bench said it is a question of jurisdiction. The GFC order, even if pronounced and disclosed, should not be given any effect to, remanded it back to the Honorable Single Judge. Pursuant to which the Honorable Single Judge's order impugned is for consideration before your Lordship. Now, this charge sheet, Millard has seen. Now Millard sees the provisions which empowers the authorities to reframe the charge sheet. Millard kindly sees the chapter on charges and matters antecedent to trial. It starts from Rule 56. 56, 57, 59 is not of relevance to us. Millard straight away starts from 60.
Rules are
60.
Rule 60.
60. I will place 60, 61, 62. 3 rules to show that none of the rules could have been invoked or have been invoked in serving upon me a completely fresh charge sheet. Rule 60, the marginal note, if Millard considers first, amendment of charge by the force court. Prima facie, Millard, this is not applicable. This is not a case where the force court has sought to amend the charge. 61, amendment of charge by convening officers. Not applicable because here also when the force court reports something, the convening officer can alter the charge. This is not a case of 61. 62, action by a superior authority on receiving an application for convening a court. As soon as a superior officer receives an application for convening a court, he shall scrutinize the charge and the evidence against the accused when necessary, in consultation, this is very important, in consultation with the Judge Attorney General or an officer detailed for the purpose by the Judge Attorney General and he. So the subsequent exercise of powers can only happen upon consultation with the Judge Attorney General, not at his own instance. 1, 2, 3, 4. Millard may not go into it. He can direct, he can return the case, he can dispose, he can return the case for further evidence, so and so.
Is this 60?
63. Rule, I am sorry, Millard, 62. Rule 62. 2A, in any other case where he does anything from 1 to 4 of Rule 1, he may either himself convene a court, or if he considers that a higher type of court should be convened and he is not empowered to convene a court, forward the case to a higher authority with recommendation that such court may be convened. This is also not our case because here the Inspector General has convened the GFC. B, the higher authority on receiving the case may exercise any of the powers given in Sub-Rule 1. And Sub-Rule 1, Millard would kindly bear this in mind that this is always in consultation with the Judge Attorney General, provided that a superior officer or higher authority before convening a general force court, petty force court shall take the advice of the Judge Attorney General. And
your case should fall in 61, right?
61 is not applicable because 61 also comes into play when the court recommends something or the court points something. Millard kindly sees the opening sentences when a force court reports to us. So 61 is not applicable. 62,
or Rule 76?
Rule, Millard?
Rule 76?
76.
Oh, when there's an objection by the
when there's an objection, that is separate. 62B, second proviso is the best case for them, which they could have invoked. B, second proviso. Provided further that the superior authority or the higher authority, while convening a court, may reframe the charge sheet on which the accused is to be tried.
As soon as the superior
Now,
One second.
yes.
But this is with regard to the superior authority.
Correct. Now, who is the superior authority? My next submission is that. Milord kindly takes Rule 181
The
under the
superior
miscellaneous
authority
officers.
is an authority superior to the commanding officer who is.
In general parlance. But so far as Rule 61 and 62 is concerned, he is not the one. Kindly takes 181 of the miscellaneous provisions.
No. 62.
Yes.
Speaks of a superior officer.
Yes.
So as soon as a superior officer receives an application for convening a court,
Yes.
he shall scrutinize the charge and where necessary inquire so and so, dismiss the charge, commanding officer to dismiss the charge, return the case to the commanding officer to be tried summarily. So none of them relate to amendment of a charge.
No.
Now, if it is a higher court, may exercise powers under sub-rule 1, the higher authority. This higher authority in the B is where the officer, to the superior officer to whom it is sent, he does not have the power to constitute a court which he feels
Right.
is adequate.
Right.
Then he sends it to the superior officer.
Superior officer.
So the or rather the higher authority.
Higher authority will come into play.
Higher authority. The
Yes.
higher authority in subsection 2
Yes.
is a higher authority in relation to superior officer.
Correct. Absolutely
In
correct.
relation to superior officer.
Millard is right, but Millard kindly now have a look at Rule 181, the miscellaneous
And
provisions.
the higher officer on receiving may exercise the powers under, provided that a superior officer or a higher authority.
Yes. Now, Millard,
take the advice of the detail for the purposes of provided further. So the second proviso is something which gives the superior authority power to reframe the charge.
reframe the charge sheet.
Correct.
Right. Now, Millard takes Rule 181 under the miscellaneous provisions.
And 181.
181. Because 61, 62 has to be read with 181. Prescribed officer under section 61 and 62. In case of officers, it should be always Director General, Roman 2.
The following shall be the prescribed.
Now, Millard.
1 second.
Yes.
Where is subsection 2 in section 61?
This refers to section 61 and 62, not rule.
Let's see the sections.
That are for deduction of payment and
Yes.
allowance, not for
So
Let me
punishment.
see now.
yes.
62. Yeah, no.
My purpose of placing this is whenever someone is proposed to be placed on trial, an officer under the GFC, all ancillary powers is to be exercised by the Director General.
But
And even
This,
Yes.
in our understanding, sir,
Yes,
your reference to 181
yes,
does not qualify rule 61 or 62.
right, right, no,
Rule 62 and 61
right,
speaks of a superior officer
yes, and a higher officer,
and a higher authority.
and a higher authority.
So superior officer here, there is no dispute, was the what commandant,
Right,
It was the IG.
was the IG,
yes,
and the higher authority may be someone above the IG.
correct, the DI,
My lord, if I may,
DG probably.
there is one
Now-
word in the second proviso, provided further that the superior authority or higher
We
authority
have
while
read
convening
it,
the.
we
My
have
lord,
read it. We have read it, we have indicated to him the second proviso
Now,
to clause B.
now,
Gives the power.
second proviso gives a limited power to reframe the charge sheet.
Hmm.
On consultation, upon consultation with the Judge Attorney General, because this power is a corollary or continuously flowing from the powers which is there in sub-rule 1. It is not in something in isolation. And sub-rule 1 starts with the proviso that in consultation with the Judge Attorney General.
Hmm. The superior officer, before convening a GFC, always takes the advice,
Absolutely.
always takes the advice of the Judge Attorney General or an
Right.
officer
Because there are legal
nominated
nuances
by
involved.
him. So
Because,
it will always be on the advice,
right,
convening.
correct. Now, if Millard is convinced to that extent, now Millard kindly again comes back to 232, the substituted charge sheet.
Hmm.
I would never say, Millard, at least to my respectful and humble understanding, Millard, this cannot be a reframed charge sheet. The office memorandum neither discloses that your charges have been reframed on the following grounds, nor the charge sheet shows it is a reframed charge sheet because the charge sheet bears the signature of the commandant first and an endorsement by the Inspector General, which is the same case on earlier occasion also. The commandant was the issuing authority of the charge sheet. So my case is, this is my best case in this matter, that an entirely new charge sheet was supplanted in gross violation of law. And even if someone argues or seeks to argue that it is a case of reframing of the charge sheet, that is absolutely unsustainable because no case is made out or borne out from the record that this was a case of reframing.
Why? What do you define reframing as?
Millard, reframing means the charges have to be altered
They
or
were
modified,
altered. They were altered.
and it has to be done in accordance with 62.
Correct. Now let us examine whether A,
Yes,
you agree with us that when, see what has happened in the charge. The substratum of the charge has not been touched.
but a higher punishment has been sought to be
Coming, is not
No.
finished, isn't it?
Yes.
Haven't we?
I'm
Have we?
I'm
We
sorry.
have not. You are getting too excited. Don't put your cart before your horse. See the situation, what has happened. The IG or whoever, the superior officer, he got the ROE, he got the charge, he looked into it, and he exercised his power under 62(1)
Right.
to convene a security force court. According to you, he had the power to do.
Yes.
What he should have done, he should get the opinion of the delegate of the Judge Attorney General,
Right.
right?
Right.
That opinion is necessary.
Yes.
Secondly, when he did that, he said, he thought, or that's what we presume, he read the charge and he said, why this is a civil offense? This is also an offense under the SSB. So the convening should be not under a civil offense, but under SSB.
Right.
This, in our understanding, is also a reframing of charge because, as you rightly say, although the substratum remains the same, the quantum of penalty enhances and a different charge is created. So it is a reframing of charge.
Right.
According to you, there should have been a clear advice from the representative of the Judge Attorney General.
Correct.
Right? This is your argument?
And on the basis of a
And
evidence which was
Right,
complete.
right. And the act that was done was on the basis of the evidence in which you had exercised your choice to cross-examine, but the cross-examination had not been done.
Right.
So in respect of evidence which had not been effectively cross-examined in the ROE, a higher charge was reframed,
Yes.
and on that higher charge, you have been put on trial before the
Yes.
security force court.
Absolutely.
However, you had ample opportunity to test the veracity of these evidence in relation to these charges before the security force court. And you in fact did it.
No, in security forces court, Millard, the procedure did not allow Millard a complete cross-examination. The
No,
procedure,
yes.
if Millard sees, if Millard kindly sees,
No, sir.
no, Millard, my second,
Final decision whether you have been proved guilty or not is by the security force court.
now Millard,
How can,
now Millard,
until and unless you
in-
give up your right.
now Millard, in ROE stage,
Right.
when the evidence is not entirely complete,
Hmm.
no cross-examination, you frame a set of charge on that basis. You subsequently reframe
Now
it.
show us that in the security force court, you had no opportunity to cross-examine.
No, Millard, the GFC record is not with me. I have been supplied with a copy. I have not gone into it, and I cannot place this also probably because GFC was not challenged before this court. I came in this court. My entire writ petition is restricted only till the stage of convening of the GFC. Subsequently, I did not get an
But
opportunity.
don't you feel now that the evidence was recorded, the failure to give the opportunity to, you participated in the GFC?
Yes, I
You
participated.
cross-examined witnesses?
Yes, my advocate. I am through a legal.
I mean, your
practitioner.
client.
Yes.
He cross-examined.
Yes, he cross-examined.
If he cross-examined, don't you feel a breach in the framing of charge will be effectively answered in that manner, and therefore on the anvil of prejudice, the irregularity in the framing of charge has to be examined from that angle?
Millard, my response to this would be the violations or deviations of the statute which I have demonstrated or I have been tried to demonstrate.
So according to you,
And Millard are substantive in nature.
huh?
Our Millardins are substantive in nature. So any violation
all
thereof,
violations, substantive or otherwise, even a violation of principle of natural justice, must yield to the test of prejudice.
but Millard, to my respectful understanding, Millard, that is only with regard to procedural violations. But when there is a substantive violation of
Any
the statute,
violation, sir.
Millard, so far as if there is a gross deviation from the statute, Millard would not approve what has happened subsequently.
Yeah,
Millard, if it is something is given in the statute in a particular manner, it has to be done in that manner or not at all.
Correct. That is.
And as a matter of Millard irony, if I can say this, the punishment which was awarded by the GFC, as on date, I have already served the punishment effectively because I am not promoted since 2019. 5 years of my promotion was taken away.
The only thing is now, if we set aside the GFC, that's a different thing, no? If it is set aside by the GFC, so if you are agreeable to punishment, what has been undergone, we can finish it here and now. But that's not the case for you from your end, no?
Yes.
We have to test the legality of the finding of the GFC.
My lord, GFC's finding is.
What
not
we
judge.
can do is we can keep the issue of GFC. You can challenge it before the single judge. But what we feel, and we'll be very clear in this, that let's say there is an violation in the framing of a charge, right? But framing of a charge is a step towards the GFC. Now, if the step towards the GFC and the nature of breach, I tell you where the breach becomes incurable. If he did not take opinion of the Judge Attorney General, that is an incurable which in the
Yes,
GFC cannot be done.
and that's what my case is also.
Let us see. The second thing is cross-examination, the crux of the thing. You cross-examined the witnesses in the COE.
COI.
As a COI. And after that, when it is placed before the ROE, they did not adopt the COI evidence, but they gave you an opportunity of cross-examination.
Yes,
But that opportunity of cross-examination was aborted
yes.
because the responses didn't come, they were not served, etc. The IG, for reasons best known to him, proceeds on that basis to convene an SFC and also alters the charge. We will call upon Mr. Mujumdar to show whether that SFC was with the due opinion,
Yes,
both with regard to convening and the reframing of charge.
correct. Absolutely.
Right? If it is not, then we will
Correct.
ask you to. If it is with the permission, in our understanding, the subsequent trial, you getting full opportunity of cross-examination, the error, if any, at the stage of reframing of charge or convening, to a great extent stands addressed, because these are all steps leading to the ultimate holding of guilt. And you,
Milord, only one aspect where I will slightly differ from what has fallen from your lordship. Milord, had it been a step-by-step process, the question of prejudice can always be covered up at a subsequent stage. But here, since ROE itself has consequences, because Rule 51 I have
what
placed,
are these consequences? Are
he
these
could have discharged me also.
Sir,
He could have discharged
he
me
could
also.
have, he did not. So what? He has
He,
today.
therefore, Milord,
Listen, today the idea of discharge, if you are acquitted in the SFC, it is as good.
that has not happened.
So that is the question. That has not happened. Is it because of the non-examination before ROE? Or is it because, notwithstanding examination before SFC, the SFC found the evidence credible in their estimation?
Correct.
So that
Correct.
there we do not see really eye to eye with you.
Milord,
Yes, Mr.
My lord,
Mojumdar.
first thing that was being heard before my lords, the charge was altered and taken up to a higher level. My lord, section 49 civil offences, the main allegation against the delinquent was he had extorted money from certain.
We've seen that.
My lord, now section 49 is with life, death penalty.
And what is the section in 48?
49, my lord.
Right.
Subject to provisions of section 50, any person subject to the act who at any place in or beyond India commits any civil offence shall be deemed to be guilty of an offence against this act, and if charged therewith under this shall be liable to be tried by a force court, and on conviction shall be punishable as follows. If the offence is one which is punishable under any law in force India with death. So this cannot
Once again,
stand.
once again. First is 34. Let us see 30.
First was 49.
Subsequent.
49 is the
No, let us see 34.
Yes,
34, my lord.
34 B.
Without proper authority extracts from
Now-
any person money, provisions or service.
Now, so far as the other other one civil offense.
That is 49, my lord.
So according to you, till now Prevention of Corruption Act, there is no death penalty. So your death goes.
My lord.
Now
so
it
that-
is falling in clause B. What is the offense under 13(1)(d)? What is the, at that time, what was the
Milord,
sentence?
I have noted in, Milord, probably, Milord,
10 years.
punishment up to 7 years. 13(1)(d) Roman 2,
Up to 7 years.
up to.
So that is why, my lord, the entire,
It's a graver offense,
which one, my lord?
the reframed charge.
My lord, 34. 34 is, my lord, 34B is, my lord, only for extortion of money.
Correct. Shall on consider for a term which may extend to 10 years.
My lord,
And clause B will extend up to 7 years.
In 13-1, but 49 was there, my lord.
49, C 49? Read 49 clause B.
In any other case, he will liable to imprisonment assigned for the offense by law in force in India or imprisonment extend to 7 years.
Correct. So what was the offense as per law in force in India? 13(1)(d), 7 years. So the maximum penalty which could have been awarded to him is 7 years.
7 years.
And here the maximum penalty which could be
10 years.
awarded to him is 10
My
years.
lord.
So naturally 34(d)
Now, my lord,
is a graver offense
lord,
than 30
kindly consider section
in the
51.
facts of this case.
My lord, kindly consider section 51 is the punishment. My lord, the punishment under the punishment clause, whatever punishments can be inflicted upon a delinquent by a force court.
Yes.
My lord, comes to 51. Starts with death. My lord, we do not read this. H, my lords. Forfeiture of seniority of rank and forfeiture of all or any part of the service.
What about A and B?
My lord, it has been not done with. We have.
Sir, what it has been done is a consequence. What ultimately happened.
A and B.
We are testing the power of your security force court to reframe a charge. What he is saying is that the charge reframing was not with authority of with the proper authority.
My lord, proviso says.
Did you get an opinion from the judge attorney?
That is in the file, my lord.
Huh?
We can produce it. Judge Attorney General was there, and he at that point of the Judge Attorney General was also a part of the force court.
Was the part of for your reframing of charge.
Opinion of the Judge Attorney General. The convening officer took it, my lord. It is in the file where we get it.
The convening officer is not the Judge Attorney General.
No, convening officer is IG.
Then did he take the opinion of the Judge Attorney General?
My lord, I have also to check punishment as 13(1)(d)(2) for prevention of corruption, and it is minimum 1 year.
Yes, 1 to 7 years.
1 to 7 years.
Yes.
But my lord, in that, he would have lost his service. He would have been removed from service.
Where?
From the, if he was punished under 13(1) Prevention of Corruption Act, he would have removed, he would have been, consequence was removal from service. And my lord, will find in section 58, the authority, disciplinary authority has the power to inflict a lesser punishment.
No, that we have seen.
So my lord, the convening officer, we have only to satisfy my lord that the Judge Attorney General had opined that yes, proceed. We have that document, we can produce it. But since we were never questioned in any court, we did not produce it. And my lord, the delinquent was defended before the force court by a legal practitioner.
No, that is, they are not disputing those issues. The main issue is
whether the charge was reframed after taking an advice from the Attorney General.
Attorney General. If that is so, that's good enough. He has the power to reframe the charge.
That is there, my lord.
So if the charge is reframed, and then the other aspect is that it was not on the basis of evidence which was cross-examined. This issue we feel ultimately, since the cross-examination was done, really does not turn here or there, and he had every opportunity to cross-examine witnesses in the court of inquiry. So in the court of inquiry, the cross-examination was there. Additional cross-examination by abundant caution had been given. The powers were there to adopt it, but it was not done. However, charges were framed. Grave charge was higher, a different charge was framed. He had power, but he had to require the
concurrence of judges.
Concurrence of the
my
judge.
lord, if I may once again draw your lordship's attention to that particular provision that my learned friend was reading. Rule 61, my lord, please take some it once more. 62, my lord. My lord, there are two sections. Rule 62(1) that says Judge Attorney General's concurrence is required.
Even proviso just see.
My lord, two in any other case. As soon as the superior officer receives an application for convening a court, he shall scrutinize the charge and the evidence against the accused where necessary in consultation with the Judge Attorney General or an officer detailed for the purpose by the Judge Attorney General, and he shall direct the commanding officer to dismiss the charge where the evidence against the accused is insufficient and further evidence is not likely to be available, and may direct him to do so if he considers it inadvisable to proceed with the trial, or may return the case to the commanding officer for being tried by a summary force court or being dealt with summarily if he considers that the same can be adequately so tried or dealt with, or may dispose of the case administratively. And if he is not competent to do so, may forward the case to higher authority with his recommendation, or may return the case for recording of further evidence if he considers the evidence recorded insufficient, but considers that further evidence may be available. In any other case, he may himself convene a court, or if he considers that a higher type of court should be convened, and he is not empowered to convene such a court, forward the case to the higher authority with recommendation that such court may be convened. My lord, it is the superior officer above the commandant who is the convening officer, his powers are being dealt with. The higher authority on receiving the case may exercise any of the powers given in sub-rule 1, provided that a superior officer or higher authority before convening a general force court or a petty force court shall take advice of the Judge Attorney General or an official detailed for the purpose.
That is what for
My lord,
convening
next
a
comes
case-
provided that he can independently reframe the charge. Second proviso does not say even to reframe charge, he is to seek advice of the Judge Attorney General, but it was sought in this case also.
Because for convening a security force court, he must take the opinion.
That he has to.
And thus, we understand what you are saying, that the second proviso does not do it. Since the second proviso is interrelated with the convening of the security force court, we would read the opinion of the Advocate General, Attorney General to be by necessary implication,
Giving consent
a
to the
part
judge.
of it, because what he is referring to, the charges, right? These are the charges on which a man is to be tried by an SFC. He requires the opinion of a person versed in law. And when he is reframing the charge for the same purpose, he naturally
it is sent to him.
Naturally, what he is sending, the Judge Attorney General must know. You say to Judge Attorney General, I am sending him for SFC for charge A, and you send him for charge B. So the requirement
my lord, we produce.
it becomes inherent in it.
We will produce. We can produce.
If you do that, then we feel that failure not to get the questionnaire may, in light of the subsequent events, not really be a vitiating factor in the final, but the finding he has not challenged. The security court proceedings.
No, I did not. I did not, because it's at this stage I came before this court.
In the meantime, this has
happened. Now, today, my lord, the
what
GM
you propose to do,
more.
take your instructions.
Yes.
What we propose to do is,
Now-
after, if we are satisfied that the Judge Attorney General has given the opinion
Yes.
with regard to convening on these altered charges, we don't see.
But I have already taken instructions. Now, in that event, GFC stands.
My lord.
The punishment awarded by the GFC has
Stands.
already been suffered by him.
So we'll record that.
Now, the only thing which will remain is the currency period. In the case of GFC, I will have a currency period of 5 years. So I would have to wait for my promotion again till 2025 or 26. Only that much if they can consider.
That we can, that GFC.
I accept the punishment of GFC.
What is the punishment that
5 years seniority loss and 2 years increment stop.
2 years of increment stuff?
Yes.
And 5 years of?
Seniority loss.
Seniority loss. Now 19 to 2024
So
due to
you-
pendency. I
You have that power of challenging before the revisional
Yes,
authority
my
or
lord.
something?
Statutory appeal is there.
So you have not exercised
No,
that. So what
since-
we can do is, we
Yes.
can dispose of the writ petition, holding that on these issues, we do not find there is a procedural violation which has infracted the finding. However, with regard to the penalty, you can apply before, but the time frame has gone.
Time frame has gone.
Then-
Time frame has gone.
My lords, if.
No, my lords are not God.
That can be
No,
considered.
one
You
way
can-
out
My lord,
is-
one thing that
we
I'd
are-
like to point out before my lordship concludes.
We can only.
Under rule 76, he has also the power to challenge, right to challenge the charge before GFC. He did not do it.
I am doing it since 2019.
No, what
Now,
prevented
if
him to go and
Mr.
remove the
Majumdar-
For us, he has done it. So we must answer that.
No,
Yes.
that is
Whether the
okay. I'm
charge
just
was
pointing out
properly
the
framed
provision,
or
my
not.
lord, that whatever.
Whether
offenses
the
were-
charge was properly framed or not, we have to answer.
Yes.
We have to answer that. And then with regard to the GFC, what we can say that he is at liberty in accordance with law to appeal before the authorities for reduction of the penalty.
Only the currency period, if that
No,
is
no, my
removed.
lord, I-
We are not
No,
your
no,
employer.
No, Millard, I am saying for consideration
We
of
are
Mr.
not your
Majumdar.
employer, sir.
If Mr.
There
Majumdar
are-
is agreeable to
we
that.
can be very clear with you.
No, who under
If we,
TCO
if we
IG.
found a member of the force started taking mobile phones for the purpose of avoiding contract, we would have dismissed you from service. All right.
No, Millard,
What is this conduct, sir? We are not going into that because we are a judicial review court. We will only see whether procedures are correctly followed or not. What they do with you is their headache. Right? So, Mr. Majumdar, Tuesday you produce the records. An advance copy of the records can be.
My lord, ROE already has it.
No, sir, ROE,
The opinion of the judge attorney.
the judge attorney and the SFC records.
GFC record he has.
GFC records I have.
You have.
Yes. The
Okay.
entire.
Every record has been given to
So
only the
you
opinion.
just produce the opinion.
And my lord, just since your lordship has indicated, he can exercise the right of appeal because pendency in the court of law will order limitation. There was a stay.
Provided, Millard, the charge is framed properly. Otherwise.
Correct. If you win on the ground of charge, so there is no problem, matter will again go back for reconsideration.
Right.
And
Now-
then you might be dismissed.
Maybe, I don't know.
Right. And so.
My lord, he has already availed the option of
Who
preferring an
has
appeal.
appealed against that?
No, appealed against. It is pending before the
So
right.
what we will say that the appeal shall be disposed of on merits, subject to the views given by this court. We are just limiting ourselves
Since
to
my
the
lord,
validity
since
of
my
the
lord, if-
charge.
let us assume that if lordships find something wrong in the charge, it will go back to the again reframing of charge.
What else?
So then the appeal becomes in fact process.
In fact, we'll set aside the finding. We'll set aside the finding then. Mr. Majumdar, in our understanding, the jurisdiction of the officer, not commanding officer, the
Convening officer.
convening officer is on the basis of the ROE and the opinion of the judge attorney general. Now, ROE we have seen, in the ROE, there was the COI where he had cross-examined. In the ROE, the cross-examination was not complete. However, on the opinion of the attorney general, he did not consider that evidence to be insufficient and proceeded to convene. He could have found it to be insufficient as a clause D and send it back. He did not find it insufficient and proceeded. Thereafter, even if there was an infraction to that extent, as he would like that this should not have been done, he should have been given further opportunity to cross-examine, that stands substantially addressed by his opportunity to cross-examine the same witnesses in the course of GFC, which was done subject to the result of this petition by the GFC, by a lawyer, competent lawyer of his own choice. In this situation, we find that this has not been a defect of such nature which has prejudiced the regularity of the proceedings, right? However, with regard to the other issues, including the quantum of the sentence, quantum of penalty, he has approached the statutory authorities. We keep these issues open before the statutory or appellate authority to be decided in accordance with. In this way, we can dispose it of.
Yes, Malad.
Correct.
Malad, I come back on Tuesday with the judge
And
attorney.
give an advance copy to him on
Millard,
Monday.
can it be on Monday, Millard?
No,
Monday, we are. We
Right,
can.
right,
Let us do like this, we'll keep it on Monday. If we can do it on
My
one
lord,
day,
please, my lord, keep still.
you have some difficulty. He has some difficulty. Let us dispose of this.
Mr. Ghosh knows that sometimes I suffer another injunction from a different quarter.
All right. More or less, this is the
Yes,
crux of this matter.
Grateful, my
So
lord.
let us thankfully have a hiatus on this.
Grateful to my lord for the patient here.
Thank you.
With your leave.
But they give me permission to. We'll come back after 5 minutes. Third learned counsel for the parties, Mr. Mojumdar seeks time to produce relevant document adjourned till Tuesday.
NRL to submit before your lordship that who is the competent authority, my lord.
Yes.
Lordship, I have taken instruction, Lordship, the special land acquisition officer already has passed the order. The order. And the compensation amount already paid 18,765,000 for the land and crops and trees, and 12,05,451 for non-residential structure.
That is a separate issue, my lord. That is now under challenge before the learned single.
Right.
Here, my lord, we were aggrieved, as your lordship.
So
There is a joint
nothing
inspection.
remains in this.
Because my lord, the competent officers are two separate officers.
So that you can argue before the compensation, that again it should be referred.
Because that was issued in respect of Gale.
The
This is
order
in
reflects
respect.
that there is a joint inspection, there is no.
This is in respect of your
residential
lordship.
structure,
Sorry,
second place.
Correct. Who is the competent authority according to you?
72 page, my lord,
Competent
kindly
authority
see.
is the, land acquisition.
But the records say different, my lord. Page 72 of my stay petition, my lord. Respondent number 5 is the competent authority in respect of NRL. Kindly see.
Ordered appellant contents. Appellant has assailed judgment order dated 16/11/2023, where his writ petition was disposed of directing special land acquisition officer and competent authority under P and MP Act 1962 to decide whether the petitioner's land had been acquired, and if so, compensation paid to him. Good stuff. In doing so, it was further directed that the competent authority of
Respondent number 5, Numaligor.
of respondent number 4
is Numaligor Refinery Limited.
of respondent number 4 of Paradeep Numaligor. Who is Paradeep Numaligor? Respondent number 5, competent authority of Paradeep Numaligor pipeline project and Numaligor Refinery Limited were to be heard. Good stuff. We are informed that the order has been acted upon and the special land acquisition officer has passed a reasoned order, passed a reasoned award of compensation in
May I be
favor of
permitted to
the
interrupt?
appellant.
Sorry, madam, may I be permitted to interrupt, madam? The order which my learned friend is saying has not been passed in pursuance of this order impugned. It has been passed in pursuance of an earlier writ petition, my lord. This order, in my respectful submission, my lord, and subject to correction, has not been acted upon till date.
Yes.
The order reflects that the order has been acted upon.
At which order, my lord, will kindly see? That is the order, my lord.
You have only one copy, right? You have only one copy. You have a fantastic memory that you can recollect everything in this order. For heaven's sake, you are addressing a division bench and we expect some degree of assistance. Really?
In all possibility, my lord, that was passed in respect of order passed in WPA
Oh, yeah,
430 of 2023.
430.
Yes,
Then?
that is the other writ petition, my lord, not
All
the
right.
not the order under
We are
challenge.
modifying this order and saying competent authority will take possession. Now, okay, the learned counsel for the respondent authorities, learned counsel for the appellant submit the learned single judge failed to consider that the notice that the matter ought to have been considered by respondent number 5. That is the competent authority of Paradeep Numalgarh project, pipeline project, who had issued the impugned notice.
At page 72, my lord.
Page
72 of my statement.
impugned notice at page 72 of the stay application under the Pipeline Key Act, what is that act?
It is the, my lord, Petroleum and Minerals Pipeline Act 1960.
Under the Petroleum and Minerals Pipeline Act 1962, hereinafter referred to as P and MP Act 1962. Full stop. Learned lawyer for the respondent authorities submit in a similar matter being WPA 430 of 2023 by and with the issue of compensation was decided by the special land acquisition officer. We have considered the materials of these tribal submissions of the parties. Full stop. Annexure notice under PNPA Act issued upon the petitioner, upon the appellant, notice, show cause notice under P and MP Act 1962 was issued by respondent number 5, the competent authority of so and so. Under such circumstances, competent authority under so and so, learned counsel for the appellant submits. Special land acquisition officer is not the competent authority for Numagor
refined pipeline.
for
Numaligarh
Paradip Numagor pipeline project. Now, unlike Gale project, which is the subject matter of WPA 430 of 2023, Special Land Acquisition Officer is not the competent authority for the present project. In light of the aforesaid, this is not disputed on behalf of the respondents. In light of the aforesaid fact, we modify the order passed by the learned single judge and direct that respondent number 5 competent authority shall give an opportunity that instead of special land acquisition officer, respondent number 5 competent authority shall give opportunity of hearing to the appellant as well as respondent number 4 Numaligarh Refinery Limited and pass a reasoned order with regard to the issue of laying down pipeline and compensation to the appellant with regard and grant of adequate compensation to the appellant in with regard thereto. Reasoned order shall be passed within 8 weeks from the date of communication of this order. With this modification, appeal is disposed.
Grateful, my lords.
Next. No.
I'm for the petitioner.
Yes, Mr.
You kindly come to page 128. I'm coming to the order. I need the complete equitable justice. Can you come to page 128 for a moment? This is an improved notice.
128.
My lord, the understand is going, I am one of the petitioners, is going to inform you that the West Bengal State Agriculture Market Committee has decided to execute a project. As your structure is within the proposed work site, it is required to dismantle and vacate the position for the said premises. After completing the project, you will be rehabilitated. They have rehabilitated and previous place to continue your business as per government terms and conditions. Now you are required to vacate the position. We the occupiers challenge this notice on the 2 grounds. That this is not the land of the Regulatory Market Committee. If you also kindly come to page 44, this is land of the collector. At page 44, one can come. This is land of the collector, and secondly, it is recorded in our name as a
Yes, what you are showing?
This is at page one, I'm continuing on page 44.
Uh,
This is a government land.
Government. 44.
At page 44,
Hmm.
the BLO said is a government land.
Government land.
Then you also can come to 112, the record of rights. At page 130 is a relevant. This is recorded in our names, Bina Anumoti Dong. So, my lord, we are occupier, unauthorized occupier,
Okay.
page 113, just got it, my lord. So, my lord, my lord, if I need a complete just from your lordship.
Yeah, rehabilitation is the maximum that you can get. Then what then?
That time, my lord, I'm now coming. I said my clients that you can't stall the development. Now only, my lord, the BLRO and the SDO will intervene and will be rehabilitated in terms of the government with a long-term settlement. And see, my lord, if you guys can allow me, I show one, this is, my lord. I give the books or I give the, this, sorry, man. It's for land, man, or 38, my lord. This provision is there. Your lordship, this is original land and land use manual. Lands used for non-agriculture purpose are often found to have been in possession of a person long period without any lease. The period of possession in such case exceeds 12 years in the person in possession. If agreeable, may be offered long-term settlement. If not, he may be permitted to remain on payment of fair equal rent.
You have followed it.
I don't stall.
Appellants are unauthorized occupants. Appellants claim they have been carrying on
But they took the license
business
from me.
as stallholders on government land. Respondent
Market committee man.
Respondent number
I say, man. Sorry, man.
4,
Yes, sir. 4 and 5.
4
And 6.
and 6. 4, respondent number 4, marketing committee
Regulated market.
through its secretary did not have legal right, did not have authority to issue notice for their eviction. Full stop. Learned single judge failed to consider this issue and dismissed the writ petition. Dismissed the writ petition. He learned counsel further submits that his clients being in settled possession cannot be evicted save by procedure established by law. Learned lawyer for state, you are appearing for state?
Yes, led by Mr. Learned AGP.
What, it was done by, this was with your consent?
My lord.
This marketing committee exercise was with your consent? Was it in consultation, the project that they are setting up?
My lord. Mine says no. But they said, suppose this is their land.
We have to take instruction, my lord.
All right. Learned lawyer for the respondent authorities submit that the appellants are unauthorized occupants and are standing in the way, are unauthorized occupants, and they have been assured and were called upon to vacate the land for execution of a market complex by the marketing authority committee. We have considered the impugned notices issued upon the appellants. Appellants are unable to demonstrate before us that they were lawfully carrying on business on the plot.
But carrying on the business lawfully, not
lawfully,
means
that they were lawfully occupying government land.
License fees, they have to pay. They have to
What license? License is only to carry on trade. Where you are carrying on trade?
pay. No.
In village,
No,
so
no.
and so.
No, license for the land, my lord. Stall, for the stall.
So that is recorded unauthorized license, unauthorized
They,
occupation.
sorry, ma'am. They took the license fee first. Can you see that? Well, I just, sorry, my lord. Can you please 45, 41?
They were illegally occupying the land.
What was they took the license fee?
They were illegally occupying the land, full stop. Mere permission.
Settled position here.
That we are holding settled possession. So you cannot be.
Sorry, my lord.
Now for this is against the notice. Have you been evicted?
No, I have not been evicted.
So that eviction cannot be by the marketing committee.
Yes.
It must be through the processes of law.
Even my lord, we are ready to, this is Nirada, I talked to
Wait,
them.
who is it for the marketing committee?
Nobody appearing, my lord, but suppose their government has sometimes appeared. Your lordship, can you write a
Sir,
wicket? Because
who
I
is for
don't know
marketing
call.
committee? You are representing.
Well, they are the state government.
Let us see. Marketing committee is. Then marketing committee, who is for the one? Let us give a notice to the marketing committee before.
But lordship, only,
They will be get whatever, where they will go. They were given, we have gone through the annexures to the stay writ petition as well as the stay application. We are not convinced that appellants are lawfully. We are of the view that the appellants were in illegal possession of the land in question. Notices were issued by the respondent marketing committee to upon the appellants to vacate the land, to dismantle their shacks, to dismantle their shops, to vacate the land for construction of a market complex. Notices clarify that the appellants will be rehabilitated as per government terms and conditions. In view of the aforesaid assurance, we are of the opinion appellants have no legal right to obstruct the development.
No, we not obstruct, my lord. Not, I'm sorry.
Have no legal right to stand in the way of setting up of a market complex which is in public interest. Under such circumstances, we find no merit in the appeal and the appeal is accordingly dismissed.
You also direct them, kindly, can you?
Direct them to what?
They said they will rehabilitate.
As per government.
But we are apprehending what, my lord, you also see that suppose after market will not be for 3 decades we are there. You say kindly they will be rehabilitated under the supervision of the government. This is only.
That is exactly what they have said there, as per government terms and conditions.
You also kindly.
Acha, learned additional Advocate General assures the court that necessary steps shall be taken.
For their rehabilitation.
Additional government.
Additional government
For the
leader
rehabilitation.
assures the court that rehabilitation shall be done as per government terms, as per the government terms and conditions.
As my lord indicated
In the notice, as per the assurance in the notice, in the impugn notice. Yes.
Careful.
Yes, next matter.
This is by the hawker matters.
Hawker matter. What
Yes,
we have
we both appeared.
Olga telling.
Well, Olga is now go.
They are gone.
I know.
Sodhan Singh.
But these provisions.
Olga Tillis and then Sodhan Singh.
Sodhan Singh is not Bombay.
Delhi.
Delhi from Bombay has come. That Bombay hawkers.
Yes.
My lord. These days, my lord.
Now, even rehabilitation is not necessary.
Division bench says that rehabilitation, then Supreme Court says no.
Even rehabilitation not necessary.
Kodihat, my lord.
If you are illegal occupant.
Kodihat, my lord. Yes.
The lawful business houses, you are saying in Calcutta, the lawful business houses they do not get frontage
Yes.
because of the illegal.
My client's house, my lordship knows that it
Then-
is entirely covered.
Entirely covered. Thereafter, the municipal corporation said that you have to remove those
Yes.
plastic covers.
Kiosks and
So
kiosks.
that there is visibility of the shop. One who is paying tax, electricity, he cannot be seen. Person who is illegally occupied,
In Goliath and
his shack is only visible.
in Goliath and in this.
How can
And
they
these are,
permit that?
these are.
There's a limit to everything.
Sham Bazaar area.
Yes,
Yes.
next matter.
And for the appealing milords, yesterday milords pointed out there were defects in the
Yeah,
appeal.
defects.
My advocate on record, she has corrected the defects. Milord.
Is let them file affidavit. File your affidavit. What to, he is saying that the matter should have been decided in the domain of public law
public law
compensation under the public law domain.
Fatal accident, there is direction for compensation on a fatal accident.
Ah. What? NHAI, who is appearing for NHAI?
No, the national highways belong to NHAI, but it is maintained by this respondent number 9 division milords, which happens to be the respondent number.
All right, affidavit in opposition, we filed 4 weeks. Reply 2 weeks, matter will appear 7 weeks.
I'm different.
Next.
My opinion. Yesterday, possibly the affidavit of service was filed, but due to connectivity issue, my lord, I was not able to
Yes.
address your lordship. My lord, can one, there is an application for condonation of delay.
Service complete.
Yes, my lord, affidavit of service was filed. Yesterday it was filed.
Completely done.
Hand service was effected upon state respondents.
Oh. Yes. What do you say? You can apply afresh. Nothing more. 91, the person had died.
Yes, subsequently,
There is no question of the license inheriting.
no,
to the-
I am not on that.
Then,
We had applied afresh.
so you apply afresh, that will be considered in accordance with law. If the licenses at all are given, are forest licenses given now?
Yes, my lord. Actually, those documents were not brought into record. before.
Whatever, delay condone,
Great.
appeal, appellant are the heirs and successors of one Budulal Agarwal, who had a forest license. Budulal died in 1997. In 2000, it is 1997. After 5 years, appellants made a representation for grant of forest license. Thereafter, they renewed their prayer in 2022. Since no steps were taken, they approached this court. Learned single judge rightly turned down their prayer on the ground of delay in latches. That apart, we are in wholesome agreement with the learned judge. More so as the license is not an heritable asset which will devolve upon the heirs and successors of the deceased licensee. In light of the aforesaid, we are of the opinion nothing survives in this appeal. Appeal is accordingly dismissed.
My lord, if your lordships kindly.
We are
observes
not
that-
observing anything.
that
We
we
are
are
not
at,
very
we are
clear
at
whether
liber-
forest licenses are granted presently. If they are granted,
My lord, we are at liberty to apply. afresh, my
you are
lord.
always at liberty. Sir. Next,
Grateful.
29. Yes.
My lord, in item 29, I am appearing for respondent number 4.
Yes.
Who is the petitioner?
This is an interim relief.
Yes, my lord.
Then-
And the affidavit has already been exchanged. Matter is in the final
All right.
court.
By issued order dated 15/12/2023, learned single judge had vacated the interim order with regard to interim order which restrained the state respondents from proceeding with the construction of tea garden house for workers, for tea garden workers.
That is called, my lord, Cha Sundari.
Learned judge observed that the project was for poverty-stricken workers and the case of the unsuccess and adjudication of a case of an unsuccessful tenderer should not stand in the way of a project for marginalized sections. Be that as it may, we are informed that the affidavits have been exchanged and the matter is ready for hearing.
My lord, another aspect,
Yes.
we have already completed 65% of the work.
Be that as it may, we learned counsel for private successful tenderer bidder contends that the nobody is appearing for appellant.
No, my lord, no is there.
All right,
Yesterday,
then we shouldn't pass any order. Nobody appears for the appellant. Additional Advocate General appears for the state and submits that the project is nearing completion. This is endorsed by learned advocate appearing for the successful tenderer, successful contractor, that is respond number 4. Under such circumstances, appeal is dismissed for default.
Lord.
We thought that someone is appearing for the appellant.
Yesterday he is appeared, my lord.
Yesterday,
Couple of times, yes.
Dismiss for default. Dismiss for default.
Grateful, lord.
There is nothing survives in it, my lord.
Huh? Section 5 থাকলে both dismissed for default. Application for condonation is dismissed for default. Appeal is consequentially appeal is default. Taken. Yes. Next matter.
Obliged, my lord.
Your first CGST. That yesterday's matter.
Yes, you have gone through the documents.
Yes, yes.
So they request.
I had to talk with the department. In view of the yesterday's submission. If the learned court, if the honorable court will pass necessary order for depositing 7.5%, in that case it is.
And adjudicating authority.
There is no difficulty.
Yes.
Only one thing, one indulgence, but at that time courts, since we have been put on a higher slab because of the 40% rebate was not. Can it be 5%? That's.
If it is 7.5, we will demand it. But have you gone through the documents? They are relevant.
Not the entire document. It is a document in line with the Bolpur Commissionerate. That is the issue. But the talk was going, and they said, "Oh, all right."
Because what we found was one of the certificate says that this is for agricultural purpose.
Free certificate, right?
So that certificate was issued by the state government. Yes.
So that is binding.
All right, at the time of adjudication,
those annexures will be looked in.
At the time of further adjudication, it will be.
Learned counsel for appellant submits. Learned judge failed to take into consideration that the fact that relevant documents submitted by the appellant had not been considered by the adjudicating authority, that is respondent number
It will respond number one.
That is respondent number 1. No, principal commissioner.
No.
Respondent number 2
No, Lord, it will be respond number 1 who has passed it.
by, that's assistant commissioner. He is the one.
He's the
The
one.
order passed by principal
But
commissioner.
it should be commissioner. It's not assistant.
Then you correct the question.
Order passed by assistant. Assistant commissioner.
Assistant commissioner? Or principal commissioner? Principal commissioner. Order passed by principal commissioner. Respondent number 1 should be principal commissioner. By the principal commissioner, CGST Bolpur Commissionerate. Full stop. Learned counsel appearing for commissionerate. Full stop. We have gone through the impugned order. We have gone through the impugned order as well as we have gone through the papers annexed to the stay application. By order dated in the records of proceedings dated
23.
no,
Page 74.
where you undertook to submit
Page 74.
by in the records of proceedings dated 23 we have gone through the records. We have gone through the impugned order order passed by the learned single impugned order passed by the learned single judge, as well as the papers annexed to the stay application. Learned single judge opined appellant had been given adequate opportunity of hearing and there was no violation of principles of natural justice. Adequate opportunity of hearing, including personal hearing. There was no violation of principles of natural justice. In light of such observation, appellant was relegated to the appellate remedy, statutory appellate remedy. At having perused the next paragraph, having perused the annexures to the stay application, we note records of proceedings dated 23/2/2023 show the appellant had undertaken, appellant through his representative had undertaken to submit reconciliation statement, copies of agreement with work orders, payment certificate, and other relevant documents within 7 days to claim benefit of mega exemption notification 25/12 ST. Full stop. Thereafter, annexure P9 to the stay application shows by letter under covering letter dated 25/4/23 received appellant submitted relevant relevant documents before the adjudicating authority. Full stop. But the adjudicating authority relevant documents before the adjudicating authority to demonstrate that the services were exempted from tax in view of the aforesaid exemption notification. However, the adjudicating authority completely glossed over the documents submitted by the appellant assessee and came to a finding came to a finding as follows. Came to a finding as follows. Discussion and finding. Came to a finding as follows. এই I find থেকে এতটা 218 ওই হ্যাঁ
প্যারা 5.5
5.6 5.6 last
I find
এই এতটা
Is not an exempted service.
হ্যাঁ the only one. From the aforesaid finding clearly demonstrates non-application of the adjudicating authority to the documents submitted on behalf of the appellant claiming exemption with regard to taxable services enumerated as items 2 to 6. Enumerated as items 2 to 6 in the preceding paragraph. কি ওরামায় করো না enumerated ওরামায় করো না claiming exemption with regard to some of the services which is the subject matter of adjudication, which was the subject matter of adjudication. This is clear. This demonstrates a manifest error apparent on the face of the records, which has prejudiced the appellant, It is trite law. Now, existence of alternative remedy is a self-imposed restriction and does not divest a court of its powers, of its extraordinary powers under Article 226 of the Constitution of India. A writ of certiorari, is a discretionary remedy, and the writ court, notwithstanding existence of alternate remedy, may in appropriate cases invoke its powers when a manifest error is evident in the records, evident from the records, palpable, evident from the records. Present case demonstrates, in the present case, adjudicating authority came to a palpable order of the adjudicating authority demonstrates a manifest error on record inasmuch as it held that documents had not been filed by the inasmuch as it held copies of agreement / contract, reconciliation statement, bill, invoices, and other sufficient supporting documents had not been submitted by the assessee to demonstrate that some of the services are not taxable. That is, learned counsel for the state also admits, learned counsel for CGST also admits that documents were submitted before the adjudicating authority.
Part of the documents, not the
Some of the
some of
submitted,
some of
some documents had been, some documents which have relevance to these, some documents had been submitted, some, we'll say, just say documents, submitted documents had been submitted, which and had not, by the SSC, but had not been considered by the, but had not been considered by the adjudicating authority. He contends the matter may be, he contends subject to, he however contends part, he however contends part of the, he however contends some of the services related to, he however contends some of, one of the services, one of the work orders related to protection / improvement work on riverbank and did not, and was not eligible for exemption. He contend in this backdrop, he contends in the event the appellant secures the state by furnishing, by depositing 7.5% of the tax assessed by the authority, the matter may be the matter may be remanded to the assessing authority for adjudication in light of the documents submitted by the appellant assessee. Full stop.
Your Lordship, just one line. Just. The reconciliation statement and some other documents were not submitted.
Correct. So we have said that, let it be.
My one line submission may kindly be recorded.
Documents apart from the relevant, some of the documents had been submitted before. We'll make some of the documents. We are not
including reconciliation statement and some tenders were not submitted.
So we are not going into that issue. We are saying
my submission. It is my submission. Just
contents that though some documents were submitted, reconciliation statements had not been furnished. He, however, admits that the documents submitted had not been considered by the adjudicating authority. He contends in adjudicating authority and in the event adjudicating authority and in the event the assessee deposits a sum of deposits 7.5% of the tax assessed in the impugned order, the matter may be remanded for fresh consideration, for reconsideration in light of the documents submitted.
If required, those documents, that reconciliation statement for
then we are making an open remand. All right, maybe remanded to the authority for fresh consideration. We have, in light of the aforesaid submission made on behalf of Learned Counsel for CGST, and now in light of the aforesaid submissions, and as we are of the opinion, there is a manifest error on record. We remand the matter, error on a record, which has affected the fairness of the decision-making process with regard to some of the decision-making process. We direct upon the appellant assessee furnishing, depositing a sum of rupees 7.5% of the assessed tax in the impugned order. The matter shall be remanded to the adjudicating authority, who shall consider the documents, who shall give opportunity, who shall consider the documents, who shall give opportunity to the, who shall consider the documents already deposited by the, already furnished by the appellant and give opportunity to the, opportunity of further hearing to the appellant and pass appellant, including submission of additional documents in plea of, in support of his plea for exemption, and pass reasoned order within 12 weeks.
12 weeks.
From, or within what, 3 months?
3 months.
Within 3 months from the date of communication of this order. In the event the appellant fails to deposit the tax liability within fortnight from date.
But it makes it 4 weeks, 4 weeks.
No.
But since the amount is huge, 4 weeks.
Within
4 weeks.
Within 4 weeks from date, the impugned order
Yes.
shall remain, the impugned order, we set aside the impugned order and direct, the impugned order shall remain unaltered. Impugned order shall remain unaltered. All right.
4 weeks.
Not revived. So what we do is, we suspend the impugned order.
Your lordship, if he not deposited the amount in the, if he fails to deposit the amount within this, stipulated period.
Impugned order shall remain unaltered.
Resuscitate again, once again.
Ah.
And it will-
The impugned order shall stand revived.
Revived.
Otherwise, the impugned order shall remain suspended. And
Your lordship, 3 months from the date of deposit or date of communication?
3 months from the date of deposit.
Date of deposit. That
we will correct.
In order.
We'll correct.
Grateful.
Very exceptional. Generally, I do
Yes,
not
sir.
do it. But we find a very palpable error on the face. Very palpable. If he had considered and said that I don't find it is enough, we've gone to the appellate court. But absolutely on the face of it, he is not considering those documents. And one of the documents, at least in our estimation, clearly says it's for agricultural purpose, the laying down of the. So if that is so, then at least from the AS form, items 2 to 6 is entitled to exemption. 1 you are not.
In case of
We'll see that 250. Other matters.
I will appeal for the appellant.
Who is for the other side?
For the Siliguri Municipal Corporation.
Municipal Corporation.
Now, if you kindly takes the order impugned, the last paragraph,
Demolition.
demolition. Now, I have gone through the papers very carefully.
You are for whom?
I am for the appellant.
Responding.
No, I am for the appellant against whom the order is directed. Now, Millard would, in my stay application, Millard, the report of the municipal commissioner is annexed, which originally had identified the alleged illegal constructions. There were two headings on which the illegalities were pointed out by the commissioner. Substantially, that has been demolished in the meantime. I have done that at my own instance. Today, Millard, kindly, this is my respectful submission, kindly stays the order for a limited period of time. Ask him to conduct an inspection within 3 days or 7 days.
No stay, no stay. You pass an order, you hold an inspection and give us a report whether the appellant has himself demolished the unauthorized construction.
Let him have an inspection. And let him point out what are the
8 to 11.
Any difficulty on that? Appellant contents.
In fact, as per the first report, I have already demolished the first
Millard, there are
violation and the fourth violation.
Millard, there are
And there
Who
is
is for
already a stay
11?
order
Who
in-
is for 11? 10 and 11.
I'm for the.
Oh, you are for every
Yes.
8 to 11.
8 to 11.
You are the private respondent.
Yes.
Yes.
On your complaint, the demolition.
No, on their complaint, it was initially started. Subsequently. they
Oh,
found the
now
violation-
both fighting against each other, the house is being demolished.
Throw stones.
At
in
your,
the middle.
at your own house. Now you want to compromise and not to
No, Millard, there were, whatever has been pointed out, we have substantially complied
let
with that.
municipality have a fair inspection and submit whether
There was specific direction to have an inspection, Malad, in the.
আমার পার্টটা বলছি।
ও আচ্ছা আচ্ছা ঠিক আছে।
So far as his party is concerned, Millard, the honorable single bench in his writ petition has protected him and said SMC to conduct a fresh inspection. So I am saying in appeal that I have also substantially complied. You conduct an inspection and point out if there is any further deviation. We will look into it.
where is the report?
Yes, Millard takes
From page 71.
70, Millard, it starts from 67. Oh, sorry.
Page 78, Malad.
I'm sorry, Millard, 70.
No, 77. The order of
Oh,
the commission
77.
starts from 71.
77 Malad.
Oh, another step. 77. তুমি রিপোর্টটা দেখো Millard takes page 74 once, Millard, from the reasoned order.
Paragraph 8, তাই তো? Paragraph 8. Also, paragraph 8. Basically, it's a old building.
So there is a demolition order by the commissioner 19th November
Yes.
2023.
Yes.
You shall submit a report with regard to the fact whether the demolition as per that order has been undertaken or not.
Now they moved the petition, it was also carrying up to paragraph page 74. With the point number 3, this is the violation that has been committed by them. Now with regard to this, the violation, they have obtained the stay, they themselves have undertaken that with point number E1 and E4, they themselves have demolished and stay with regard to point number 2 and 3. And now the act.
Where is 2 and 3?
Millard, page
Same
74.
paragraph.
74. Yes.
Paragraph number.
Paragraph E is their violations,
Their violations.
F is our violations.
So with regard to F, you give the report?
Yes, because
where is your writ petition?
They have not preferred appeal against it.
No.
Writ petition, it has been filed subsequently, my lord, after the demolition order has been passed, my lord. ওই order টা আছে না তো?
That order we are carrying.
It should be assigned to us and disposed of together. Why should why your writ petition will remain like this? Already complied. Have you filed the report in that?
No, our inspection is yet to be conducted with regard to it.
Then
So inspection of the entire premises can be, what can be done?
you make a prayer for assignment of this writ petition before us.
My lord.
Appellant submits, learned counsel for appellant submits that he has demolished the unauthorized constructions in his portion of the building as per clause F of the demolition order dated 19th November 2023. Learned counsel for private respondents submit they have taken out a writ petition. They have taken out a separate writ petition being WPA 847/2024, wherein they stated they had removed the unauthorized construction from their portion of the building
With regard to
referred to in clause
E1 and E4.
2(3).
2(3), my lord, there is, it is a matter of argument, my lord, that it has been stayed, my lord.
Just to be clear.
Since as per building rules, clause 11 of the building rules.
They have said those are minor
Yes,
deviations,
ma'am.
not
I'm
required to
protected
be
under
done.
clause 11 of the building rules, ma'am. That is yet to be decided.
The cantilever has to be broken.
That has been.
No.
Oh, my lord. Cantilever.
3.
My lord,
We can understand 2. That is the change, internal change. If it does not change the structural safety, 2 is all right. But 3, sir, is a projection outside the building. It has to go. That cantilever. We are not making any comment. Submit that prayer has been submitted that they had undertaken to have removed unauthorized constructions in their portion of the building referred to in clause E, Roman I and Roman 4 of the demolition order. Remaining other constructions are within permissible, other deviation, it is alleged that other deviations are minor and the matter is pending before the learned single judge. In light of the aforesaid, in light of the submission of the appellant that they have removed the unauthorized constructions in his portion of the building, we direct
Paragraph F.
Unauthorized construction of the building as described in paragraph F of the report. We report the demolition order. We direct the respondent number 4. Commissioner will conduct inspection.
Engineer.
The
6, 7.
engineer, 7. Or the 6, the executive engineer.
Respondent number 6 shall conduct inspection of the building and submit report whether the unauthorized constructions noted in paragraph F of the report of the order has been demolished or not. Full stop. Report shall be filed within 2 weeks. Matter will appear 4 weeks hence.
Will it be Millard's pleasure to at least put the
Needless to
order in
mention-
suspension?
No way,
for the time?
needless to mention, in the event, the respond number 6 finds that the unauthorized constructions as aforesaid have not been demolished, it shall be open to him to demolish them in accordance with law. Full stop.
Yes. Pending. কিন্তু এখানে report নেই।
You give the report. We have said that you also give and submit compliance report. Either you give a report. Your report has 2 categories. One, whether he has complied with or not. If he is complied with, end of matter. If he has not complied with, steps taken by you to remove the unauthorized construction and submit compliance report. Next.
And for the response.
Your Lordship, I'm requesting for next circuit, Your Lordship.
Okay. What is the matter?
It is GST matter.
The GST appeal, Your Lordship.
Then
Appeal has
appellate-
not been preferred
Go for the appellate forum.
Your Lordship, kindly,
against the order of the adjudicating authority. They have come.
Your Lordship, in this matter, kindly, Your Lordship, have instruction for next circuit, Your Lordship.
Next I will.
Grateful, Your Lordship.
As you lodge.
Lordship, item number 30.
Not I beg to appeal for the respondent number 2, Lordship.
Lordship, in this case, Lordship, and be preferred, again, challenging an order judgment passed by the Honorable Single Bench of Justice Hiranmay Bhattacharya in writ petition number 2877 of 2023, Lordship. Now, Lordship, unfortunately, Lordship, this writ petition, unfortunately, this point was not taken, but the petitioner therein, the writ petitioner therein did not have the locus standi to file this writ petition, Lordship. However, Lordship, actually the case is, Lordship, that this appellant petitioner and the respondent number 1, they are siblings. And there is a family dispute between them, a private dispute. And with regard to that, partition suit was pending before the learned Civil Judge Senior Division Siliguri. Thereafter, that was dismissed. The partition suit was filed by the respondent number 1, and that was dismissed. Now, Lordship, after the dismissal, that writ petition was filed. But Lordship, if I may, along with this writ petition, Lordship, along with this mandamus appeal, 2 connected applications has been filed. One paying for stay order, and one paying for the condonation of deed. And Lordship, admittedly, there is a delay of 41 days, Lordship. Now, Lordship, if kindly allows me to explain the reason for delay.
Petition.
I was the writ petitioner.
So delay is condoned. Delay is condoned. Yes.
Lordship,
Now you don't have a license. How will you carry on?
no, Lordship, I don't have a license yet, but Lordship, if I kindly allows
We
me to
will
explain.
make it clear in the event you are given a license, you can carry on business in terms of the license.
Lordship, if I may, kindly admit
Milord,
this
may I-
mandamus appeal, because Lordship, there is another can 2 paying for stay of the impugned. Now, Lordship, if I may, kindly allows me to explain. On the order given by the writ petition, in that writ petition, a single observation was made by Honorable Justice Hiranmay Bhattacharya that the writ petition, that the current occupant of the stall that is situated in Vidhan Market, in page number 2, Lordship, if I may. However, since it is not in dispute that the private respondent is not having any requisite license at present, the private respondent cannot run any business from the said stall till the requisite license is issued by the SJDA. Now, Lordship, admittedly, as of today, as we speak, the application has been made after the disposal of the title partition. Application has been made before the SJDA.
No,
and that
it is also noted You come to second paragraph of the order.
Yes, Lordship, it is noted, Lordship,
On
it is noted.
27th, what we may observe is the licensing authority may take appropriate decision in the matter.
Yes,
Yes,
Lordship.
my lord.
Right?
Yes,
After giving opportunity of hearing to.
My lord,
Yes,
actually,
Lordship.
I would like
Lordship,
to.
if I may, one point, Lordship, the reason there was no apparent need for filing this mandamus appeal.
Do you
But
have
however,
an
Lordship,
objection if his license is granted?
Yes, my lord, I have objection and I
We have-
have even submitted a representation before the SJDA.
Lordship, if I may, one
My
point.
lord, at the time of hearing of the said writ application, it was contended by the appellant here in the the respondents that I have already given an NOC,
You have not.
whereas I have not. And even if any NOC has been submitted on my behalf, my signatures were forged. And thereafter, on 10th of January 2024, I have already submitted my objection letter to the SJD and by
What
way of
let us do
supplement-
like this. Since you also wish to carry on the business, we direct the SJD authorities to take a decision on your application after giving an opportunity of hearing to both parties.
All right,
Lord,
Lordship, if I may,
Lord,
one more point,
if-
Lordship. Lordship, the NOC has been, as they're contending right now, that is not the correct stance. The NOC has been obtained from the respondent number 1. They have indeed
But it
given
is a
a
very
NOC.
simple-
Thereafter, Lordship,
Look into
after
the
taking the,
chronology.
all right, Lordship. After granting the NOC, the respondent number 1, what he does, he goes to the civil court of Siliguri and he files a partition suit before the learned civil judge senior division. Now, because the suit was pending, it has been pending since 2015. It was disposed in August 23. Because it was pending, this appellant petitioner did not file the application for mutation before the SJDA in the due course of time, because anyway it would be rejected by the SJDA since a suit is pending. That is exactly why the petition did not file before the SJDA. But however, as soon as the suit was dismissed without cause, this appellant petitioner went before the SJDA and filed the
Partition suit was dismissed.
Yes, it was dismissed by the learned civil judge senior division, and that the partition suit was filed by the respondent number 1, Lordship. So
On what ground? That,
on ground that the stall that is there, the stall that was there, Lordship, the stall belongs to SJD, Siliguri Jalpaiguri Development Authority.
All right.
Now, on that was now since and the stall was it was in previously in occupation of the father of the appellant and of the appellant petitioner. The appellant petitioner, being a refugee from the then East Pakistan, he was allotted the stall by the SJDA of RR and R department. Now, Lordship, after that, subsequently we have filed for the
after the death of under SDGA rules or as per the rules with regard to the license, after the father dies, is there any provision that the AS will
No, my lord.
continue?
Lordship, it reverts back to the SJDA.
Correct.
It reverts back to the SJDA, but because an NOC has been obtained in a amicable family settlement, an NOC has been obtained from all the legal heirs of the then deceased. This appellant petitioner obtained the NOC, and as he was about to file that before the SJDA, the title partition suit came in. It was filed, and hence we did not.
Let us do like this. If there is no objection, the SDGA will consider this issue because he is disputing the no objection certificate and go into an inquiry whether there was a valid no objection, and on that basis the decision will be taken.
Yes, Lordship. Lordship, one final point, Lordship. Kindly the stay may be granted because Lordship, because
My lord, it is stay.
no, Lordship,
and
allow me to explain, Lordship. The reason is that after the order passed on 2nd of January 2024 in the writ matter, the respondent number 1, after the passage of 1 month, that is after the limitation period exceeds, this respondent number 1 serves a notice upon the appellant petitioner, alleging that you are contempting the order in contempt of the order of the Honorable Single Bench of the Calcutta High Court. Now, Lordship, apparently there was no, as I have said earlier, there was
Yes.
that is also the reason, Lordship, why we have also filed this. There was a delay in of 41 days. We got the notice exactly after 1 month of the order, and by that time the order was already the limitation period was already exceeded. Thereafter, within 10 to 12 days, we filed this mandamus appeal, and that mandamus appeal, Lordship, as if I may, it was filed by taking the leave of this honorable court because the certified copy has not been obtained yet at that time. And Lordship, I have also obtained the certified copy in this case. It was obtained after the taking leave of the honorable court. Also, Lordship, a trade license has also been issued by the Siliguri Municipal Corporation regarding my trade. Now,
Is it akin to a
it is
license?
not. It is
issued by
not.
the
It is not.
SJDA?
Now, the issue that is to be issued by the SJDA, undoubtedly.
It was a
But
licensed property.
It's a licensed property, no doubt. But all I am praying, Lordship,
All right.
that after granting
Appellant petitioner, appellant writ petitioner submits oh, you were appellant respondent number 2.
Lord, can I just make one? Lord,
You listen to our order, thereafter make your submission. Appellant respondent number 2 submits. The writ petitioner had no locus standi to take out the proceeding before the single judge. The dispute in question relates to a private, relates to a stall which had been a stall situated at Vidhan Market, Siliguri. Now, Tribunal has no locus standi to learned counsel for the appellant respondent number 2 submits. The dispute relates to the dispute is private in nature, and the writ petition at the behest of the respondent writ petitioner was not maintainable. He contends father of the appellant and the writ petitioner was a licensee in respect of a stall at Vidhan Market under Siliguri Jalpaiguri Development Authority, for short SJDA. Upon his death, appellant had applied for a fresh license and no objection, fresh license. Writ petitioner had given no objection to his prayer. Subsequently, he turned around. Subsequently, he committed a volte-face and filed a partition suit, which came to be dismissed. Father was appellant, he contends, writ petitioner had given a no objection. And he contends, he intended to make an application for issuance of license in his favor, and writ petitioner gave a no objection thereto. Before he could submit the application, writ petitioner committed a volte-face and filed the partition suit, which came to be dismissed. Due to the pendency of the partition suit, he was unable to submit the application earlier. Thereafter, once he applied for grant of license, writ petitioner came to this court seeking seeking various reliefs.
I would like the license was applied as per their version. It was applied on 27th of December 2023, whereas the writ was filed on 13th of December. The suit was
Thereafter, that is what we have recorded. After his license, you have filed the writ petition, and the writ petition for various reliefs, learned ignoring the nature of dispute, which related to grant of license, nature of dispute between the heirs of the deceased licensee. The writ petition was entertained and the appellant was restrained to carry on business in the premises.
Lordship, one
Learned-
indulgence, if I may.
Yes.
Lordship, because in the stall, there is a said running business, which was previously a said running business. The Siliguri Municipal Corporation had also issued a trade license because it's a running business. Lordship. May this part be kindly be noted, Lordship.
Learned counsel for the appellant submits, since the death of his father, he was continuing the business and a trade license had been issued by the concerned municipality. Learned counsel for writ petitioner contends his client had not granted had not granted a no objection certificate as claimed by the appellant. After the disposal of, as a result, appellant had no license from SJTA to carry on business from the from the stalls. Under such circumstances, the learned single judge restrained him from carrying on trade and business, carrying on business from the stall concerns. Learned, we have considered the rival submissions of the parties. The father of the appellant and the writ petitioner was the licensee of a stall at Bidhan Market under SJDA. Full stop. He has expired, and with his death, the license stood extinguished. It is stood extinguished. Appellant contents writ petitioner, his brother, the writ petitioner had issued a no objection in his favor, no objection, had issued a no objection, and on the strength of that, and on the strength of such document, he had applied for a new license in December 2023. On the other hand, the writ petitioner disputes such fact and claims he had not issued any no objection certificate. Be that as it may, no license has been issued in favor of the appellant by SJDA till date. In such circumstances, we do not find any illegal SJDA till date. Full stop. License granted SJDA till date. A stall owned by under such circumstances, order direction by the learned single judge upon the appellant not to carry on business without requisite license from SJDA cannot be faulted. However, appellant has a legitimate expectation that a license may be issued in his favor. Accordingly, we direct in his favor, provided the no objection certificate submitted by him is a valid one. Accordingly, we direct SJDA to consider the application of the appellant, consider the application of the appellant for license after giving an opportunity of hearing, after verifying the genuineness of the no objection certificate and giving an opportunity of hearing to the appellant and the second respondent at the earliest, not later than 3 months from the date of communication of this order.
Respondent number one.
Respond number 1 is JP.
Lord, if your lordships kindly make it clear, 3 months from the date of lifting of MCC, my lord, the model code of conduct.
4 months. Model
Got
conduct by 4
Lordship.
months.
Lordship.
Lordship, 1 point, Lordship, the corporation, it was the Siliguri Municipal Corporation which has issued the trade license in the favor of the appellant. That part also kind of.
SJDA, we have recorded that.
Yes, and Lordship, also 1 point, Lordship, that contempt, that the respondent number 1 on in lieu of this order of this part.
I have served a contempt notice.
That contempt.
They have served a notice alleging that contempt.
We have not varied that order that he will not carry on this.
Yes.
No, Lordship, the fact may kindly be noted that they don't have any locus standi
No, it is
regarding
exactly
that,
the
because
locus
in
standi.
that
You
case they have to come
definitely have a locus
through
standi.
by the way of a PIL, Lordship, because the property admittedly
PIL?
belongs to SJDA, Lordship.
So
SJD, Lordship. Now
The law is
the
very simple.
appellant
After
petitioner
the
has
license, automatically property will go back to license.
the stall in question with regard to the issue that we are unable to persuade ourselves to hold that the writ petition is not maintainable, as the learned judge had noted that the petitioner was carrying on business from a stall owned by a public authority. Full stop. It's not a private property.
absolutely, it's not a private, but
And if it is not a private property,
Lordship,
this law no longer subsists that you have to show that there is a legal wrong to the writ petition.
actually, Lordship,
Any violation of legal duty of the public authority, a person can bring it to the
Can file a
notice.
writ.
Until and unless you show it's malified.
actually,
Yes,
Lordship,
if it is malified, no difficulty.
the fact is that
family
this
settlement
is
which
entire
they are bringing,
family
they have
dispute.
failed to produce any such family settlement.
There is no question of family settlement. If you have given a no objection, it will be considered. He has a legitimate expectation of it.
In the order, can you kindly mention or reflect about my objection letter dated 10/1/20?
We have recorded that you have objected to it, and because of that, however, he has a legitimate expectation, it will be decided within 4 months. After going into the question of veracity of your no objection.
Actually, Lordship, this is completely a civil dispute in nature that has been
Correct, but then
put under the garb of a writ matter.
you are occupying a premises which is a public property, and you are continuing the business. If you are not continuing the business, if you are not entitled to SJDA, put it up for auction. SJDA will put it up for auction.
Absolutely.
Then
No fresh license.
Grateful, Lordship.
Grateful, Lordship. Grateful, Lordship. Deeply obliged.
next,
RT4 Millard, it is showing defective Millard. I will have an inspection.
let us see what is the defect.
But I was only requesting it Millard, take it up in the next week.
Very minor defect. Just correction, memo of appeal needs to be classified in words as one preferred from original order.
Millard, kindly grants the leave. Millard, kindly takes it up
Defects
in the
be
next week.
removed 1 week.
Grateful.
Next. হ্যাঁ ওই এক্সাম কেটে যাবো ফ্রাইডেতে রেখে দেবো নেক্সট yes
My lord, my appeal, if your lordship can take it up on Monday, my lord, I could not get ready in this matter, my lord.
For the Jalpaiguri, sir, one of the respondents, answering this.
What is it?
My lord, I was a contractor, my lord, my contract was
Terminated.
Monetary money was forfeited and I was blacklisted. So the learned single bench has held the action to be correct. I'm agreed by that. So, Lordship,
File your opposition to the stay application.
my lord, there is a delay of 6 days, my lord.
6 days. We
Yes.
condone that.
Grateful.
Delay is,
Affidavit of service.
delay is condoned. Do you want to file any opposition?
That may not be required because lower court records are there. We
Or
have
lower
filed
court,
our-
you filed your opposition there?
Yes, yes.
Oh, fine.
Yeah, opposition.
So let this matter.
Can to, my lord, is the-
I think the second part of the order, one can go into, is there arbitration clause?
My lord, no, not to my knowledge, my
No
lord.
arbitration. The issue of termination, etc., if learned single judge has relegated you to a, and any hearing was given for your debarment.
No, my lord, no.
So to
But
that
he was
extent,
issued notices,
Yes.
several notices. but-
notices for what? For blacklisting?
No.
Then
Blacklisting, no notice. my lord.
if there is no notice for blacklisting, show cause why he did not complete the order can give you justification for termination and justification for awarding it to another person. Now, with regard to the quantum of loss suffered and etc., we understand that matter requires to be delegated to a civil suit.
Yes, ma'am.
But with regard to blacklisting, there must be a specific notice for blacklisting. Without that, how do you blacklist a person?
Right, I will consider this, my lord. I'll go through the papers.
Adjourn 1 week. Next circuit.
My lord, Monday. Monday, my lord. Want to finish it off.
Monday.
Actually, my lord, the difficulty is, my lord, I am not, my lord, pointing fingers at anybody, but getting mandamus appeals hearing done, my lord. Because most of the time, the honorable division benches are preoccupied with the bail and anticipatory.
So bail and anticipatory, we have finished. Bail and anticipatory.
Not with respect to this bench, my lord, but most of the benches.
We have made it now we have made it a practice that bail and anticipatory criminal matter will be finished by 11:30. From 11:30 to 3, etc.
That is why, my lord,
the
we are all-
application. Now we will next week or tomorrow we'll have a bit of a difficulty. We won't be sitting after 2. But otherwise, from Monday we'll take up criminal appeals. We'll finish one of the criminal.
Many of the circuits, my lord, those as we generally practice more on the civil side, we hardly get an opportunity to address the division bench.
So that is why.
Because of this.
That is why we made it a point. It was asked that last occasion that whether we take up criminal matters first, and saw the mandamus application was overwhelmingly.
Yes, my lord.
At least now it has come to a manageable
Yes.
number. Now it has come to a manageable number, so people can
fact,
have an opportunity.
21,
Like your
25
case,
days
that
over.
poor man, that your person who loves mobile phones,
Yes.
right? So he is
Without
waiting,
paying the price.
he is waiting for his appeal, whereas his challenge to charge is not being considered. उसका हो गया, खत्म हो गया. All right, we'll keep it on Tuesday.
As your lordship.
All right, Tuesday will. Take it.
My lords have been.
Just examine this for Zila. You are for Zila, na?
Yes.
Examine whether for blacklisting, you also see the authorities, because the best to my recollection, blacklisting is an independent exercise.
Yes.
And for that, a separate notice has to be.
Yes. my lord is-
If that notice is not given, then the order of blacklisting we can interfere.
Termination
First,
automatically won't lead to blacklist.
termination by per se, termination will not lead to blacklist. Termination and loss may be for bona fide causes.
Right.
But that, until and unless the clause says that there is an automatic blacklist, please examine that.
I will.
I have examined my first blush perusal of the impugned order is.
Even then, my lord, what has just fallen from your lordship, I'll try to find that. I mean, for some other case, I think I had come across a judgment.
Because I also feel that I have seen this line of authorities that termination per se does not lead to blacklist.
No, even in cases, my lord, I think I have that.
You bring in the
where, my lord,
authorities.
as it had fallen from
Mr.
your lordship.
Authority, you bring the authorities.
Yes.
We assure you, to the extent of blacklisting, we will modify the order.
Lordship.
Other portions, perhaps,
Other portion,
there are very strong reasons they have
To be
given.
candid, my lord, other portions, I am also not that confident.
That is why I've said, we've seen the order.
Yes.
And our first blush opinion is that portion of the order does not require interference, blacklisting we will interfere.
Lordship.
If you satisfy us,
Right.
who was the authority,
Yes.
you also,
I will.
and take your instructions. If you
Yes.
feel that to the extent that dismissal and awarding to new contractor, we are not going to interfere. Blacklisting, we are going to interfere. And if you are to blacklist, you have to give him a fresh notice. That will observe.
But I will, my lord, seek some time of your lordships to, my lord, address on the other part as well.
Don't waste our time on that. Huh?
My
Be
lord,
pragmatic,
yes.
you will get quick solutions.
My lords have been pleased to-
Theoretical arguments, don't do it.
My lord,
We are hard pressed also,
I
you know.
My
so
lord,
that-
have been,
and so many friends, the more we can,
Lordship.
every lawyer gets some advantage.
My lords have been pleased to condone the delay, my lord.
Delay
Can to, my lord.
Can to allow.
Grateful, my lord.
Matter is fixed
Yes.
on Tuesday. We'll
Affidavit of
try
service-
to dispose it of on Tuesday.
Affidavit of service has been filed. Grateful.
Yes. Oh, look at Mongolwara.
That is time for the petitioner, my lord.
क्या करेगा इतना हुआ है इतना टेंडेंसी हो रहा है देख रहे हैं क्या दिक्कत है
No, there are no delays, my lord. It is this appeal is filed over a judgment dated 19 February 2024, my lord.
You have to correct the what is this association?
My lord, actually, the story is the petitioner was.
The writ is not maintainable.
My lord,
You are a member of an association terminated membership files civil suit.
My lord, there are two things which needs to be, if at all this is not maintainable, also at least I should be allowed to put on record my submissions, my lord, at least once. I was trying to do the same before the
After
single
a
punch also.
regular next circuit bench. Your ornamental appeal will remain. 0, 0, 0. Correction defects be removed, adjourn 1 week. Next Friday it will come.
As you please.
If we get time, we'll dismiss. If you don't get time, we'll go to the next level.
As you please.
Private association, raffle.
My lord, there are 2 points, my lord, which I would like to urge, my lord, if it is.
What are the 2 points?
My lord, the first.
What public duty this public welfare association does?
My lord, the
What
first.
is the nature of public duty? First, it is not a state under Article 12. The other aspect where jurisdiction can be invoked is discharge of public duty. A body discharging public duty, amenable to it. What is, you are a member of a raffle association, they throw you out, rightly, wrongly. Well, what is the
they are not a member of a Rafael Association, man. They are a member of a Enfield Association, my lord. The president wanted to conduct a lottery, my lord, which was complained by the secretary to the police and also the joint director, my lord.
Right.
No action was taken, my lord.
Right.
And after that, my lord, what happens? This
What is an Enfield association?
it is a Darjeeling. It is a based an association. It is a old and very famous association, my lord. It might be in.
It's a club. Bikers.
Bikers association kind of a thing.
Oh, you are a biker.
I'm not a biker, but the petitioner might be my lord. He's a secretary.
I don't mean you, I mean the petitioner.
I understand.
The petitioner is a biker.
Yes.
He was a member of an association of bikers. Now they wanted to have a lottery. You said that without license, no lottery should be done. So
And the same was complained to the police
you made
authorities.
complaint, and because of that, they threw you out.
My
You are in good company. Don't stay with these sort of unlawful people. What do you want? Be a member of an unlawful association like these bikers who go for. You have your own biking association.
My lord,
You start an honest biking association.
two points we can
Yes,
take
this
into
is the
consideration.
first point. Then what is your second point?
He received an award from the president.
He?
No, that bike ambulance, they're from Alipurduar.
Acha, this Enfield association.
No, bike ambulance, there is a
Yes, another
services to the public.
correct. That is very good.
So that these bike association he ought to have
Yes.
provided.
Now,
these
what is the
services.
second point?
My
Let
lord,
us see.
if there is a violation of a fundamental right under Article.
What is the fundamental right you are
Right to
achieving?
association, my lord, 19(1)(c) is there, my lord.
Right to association.
Form
It is-
associations, my lord, is also.
Form association. So you are entitled to form an association.
The
Who
continuance,
stops you?
my lord, the continuance with an association is also broadly, it is there in many of of this very high court as well.
This very high court that you are entitled to member.
No, my lord.
Show us one judgment of this high court or the Supreme Court that removal from a particular association will entitle at a voluntary association will entitle you to a relief under Article 226. All right, we give you 1 week time. You show us authority, we will give notice here out at length. Otherwise, we dismiss this application.
As
Next.
please, ma'am. Friday it is.
Friday, next Friday.
As.
You remove the defect that in words, there's a very small, you have to just say original order, appeal against original order. That has not been stated. Yes, next matter.
I appear for the writ petitioner appellant, my lord. My junior is there, my lord, Mr. Nopal.
Yes.
My lord.
I'm appearing on behalf of all the respondents. I'm appearing on behalf.
Judgment and order dated 25th January 2024 is under challenge. Issue before the learned trial judge was whether initiation of the proceedings and framing of charge by the chairman who is not competent to initiate proceedings and frame the charge against me is at all sustainable. This was the first point before the learned child. But to kindly have a look.
Let this matter, there is no scope of relief. We'll let the paper books be prepared. Appeal was
my lord, informal paper book.
Prepare informal paper book.
I have annexed written opposition, reply, everything I have annexed.
This will require some time of hearing. This will take some time. This will take
informal paper book.
Your Lordship, may I be permitted to submit? During the course of pendency of the writ application, the respondent preferred one application under the Right to Information Act with regard to the documents that they had produced before the writ court as well as before the proceedings, and which application of the reply of the said application under the RTI Act has been obtained by the respondent. Now, the said report was not made as an annexure in the state writ application as well. So
you want to file an what is there in that report?
Regarding the medical documents that they had produced before the proceedings before the bank, which they had produced and which they are relying upon. With regard to that, we had preferred an application for confirming the genuinity of the said documents, said prescriptions that has been filed.
And what is your response?
The North Bengal Medical College has clearly denied that such medical documents were never issued by them.
But was it before the disciplinary authority?
That was, those were the documents that they relied upon before the disciplinary proceedings.
But disciplinary authority did not consider, you filed your opposition there.
Because your lordship.
All right, we have followed it. Mr. Nepal, let them file their opposition. They want to place on record some additional documents.
My lord.
Hmm?
My lord, it's a purely question of law. The service regulation has a statutory force where the chairman who is not competent to issue the charge sheet, frame the charge sheet against me can. And the punishment imposed by the chairman who is my appellate authority under regulation 50 of the service regulation 2010. This is number one. Whatever steps they have taken, they may rely every document. But issue is in contravention of the service regulation 2G, regulation 39, regulation 41, and regulation 50 of the service regulation.
But Mr. A, where have you raised that point? Where the learned single judge has considered this issue?
My lord, kindly have a look, paragraph 5.
Paragraph 5.
May I read? The learned counsel for the petitioner further submitted that the order of punishment of removal from service passed by the chairman as disciplinary authority is not legally sustainable in terms of the regulation 2G. General manager of the Uttar Bongo Kshetriya Gramin Bank is the authority who can initiate the proceeding and pass punishment. Since the order of punishment of removal from service was passed by the chairman, right to appeal, which is the statutory right, has been taken away by the chairman, is the appellate authority. The chairman has been acting in an unreasonable, unfair, and arbitrary manner, which clearly violates the petitioner's right protected under
So according to, first and foremost, the punishment order, according to you, is by the general manager and not the chairman. Now, chairman is a superior authority. So what is the harm if the chairman passes the order?
My lord. Then, my lord, kindly have a look to the regulation first. Regulation first. That is at page. It starts at page
53.
Page 54. First. In exercise of the power, page 54. In exercise of the powers conferred by section 30 of the Regional Rural Banks Act 1976, the Board of Directors of Uttar Bongo Kshetriya Gramin Bank, after consultation with the Central Bank of India being the sponsor bank and the National Bank of Agriculture and Rural Development, and with the previous sanction of the central government, hereby makes the rule following regulations, namely Uttar Bongo Kshetriya Gramin Bank Officers and Employees Service Regulation 2010. Then we will kindly have a look 2G first at page 55. Sorry, my lord.
We are saying that if a superior authority acts as the disciplinary authority, what prejudice do you suffer?
Yes, that issue has already been considered by the Honorable Division Bench of this Honorable Court.
So should place on record the division bench judgment, all right?
Straightway, my lord, I am placing that judgment.
Let them.
With regard to that, your lordship, there are certain guidelines in the regulations as well, where the present petitioner should have preferred that application to the competent authority as well. And they have not preferred such application before the competent authority. They themselves have preferred that such letters for rejoining of his service and for extension of his leave was all preferred.
These are not questions. What he's saying is general manager.
Whether the proceedings was
whether the general manager had the power to conduct the disciplinary proceeding, and the chairman was the appellate authority. Now the chairman awarded the punishment. Or in other words, disciplinary proceeding was at the behest of the chairman, and thereby their right to appeal to the chairman is extinguished. You
No,
understand?
with regard to that, your lordship, may I kindly draw your attention to case number 87 of their application?
Navangpur.
Yes.
All right, you file your
I'll file the
opposition, will consider it. Affidavit in opposition to the stay application, we
My
file.
lord, for my satisfaction, only kindly have a look to the judgment that was
What
pronounced
is
by
the
the
use,
honorable.
Mr. Park? We will not hear this matter in this circuit. It will go to the next circuit. So we want to place on record additional documents. So let them file the opposition. So here, firstly, why we do it is, if we are not with you with the first point, then the question of merits will come up, where his additional documents may become relevant. So let it be placed on record, and thereafter.
My lord, so far the first point is concerned, law is well settled. When status is
That
conferred.
is what we will consider, the first point and other points together. Let them file the opposition.
My lord, my lord.
Affidavit in opposition to the stay application be filed.
With the leave of my learned senior, my lord. But it has to come through an application, my lord, because they are relying on some additional document. It has to come through an application for filing additional document.
So let him file the opposition. In the opposition, he can seek leave. He can seek leave in the opposition. Or you file an application or place it on record. Respondent seeks leave to file additional document, seeks leave to file application to place on record additional documents. Leave is granted. Let the matter.
I'll file the opposition as well.
My lord, before the
Affidavit in
trial
opposition
judge.
to the stay application be filed within 4 weeks. Reply 2 weeks, matter will appear 8 weeks hence. In the we have given you leave, you can file along with the opposition the application for addition.
Grateful.
Extremely grateful, my lord.
Yes. Next.
Yes, Lordship, I on behalf of the appellant, Lordship.
Lordship, in this matter, Lordship, am I audible to your Lordship?
Yes.
Lordship, in this matter, I am for the opposite party respondents, Messrs. PG Enterprise. I have not served any copies of the appeal.
So?
Lordship, there is a defect, sir. So then cause list.
A defect is very minor.
Also, there is a delay, 34 days delay.
Defects be removed in the course of the day. Copy of the application for condonation of delay be served upon the respondent with petitioners. Matter will appear 2 weeks hence.
Grateful.
Deeply obliged.
Yes, Mr. Agarwal.
I am for the statement.
You are not liking to do.
Your lordship,
You are not, we are not generating confidence.
no, your lordship. I humbly pray for next circuit, your lordship. I have instructions from my senior.
Repercussion most probably. Yesterday, repercussion most probably.
Today we have remanded one matter.
Yes, your lordship.
Today in GST, we
GST matter, yes.
remanded one.
Yes.
Because there was error apparent on the face of record.
Huge.
Documents which were filed were not even, no observation was that no document has been filed. Which is an error on the face, so we have remanded it. But subject to 7.5% being secured.
7 point something.
7 point.
That is the service tax.
Service tax. Yes, service tax case, GST case.
GST.
This is not GST, this is also GST. Appeal.
This is against the adjudication one.
Then?
No appeal is the alternative remedy is the. Oh, no.
Appellate remedy is there. Then? Why should?
Your lordship, if not next circuit, can you 1 day accommodation may be given, your lordship?
Monday.
Grateful, your lordship, Monday.
Next.
My lord, I am for the appellant, my lord.
Yes.
My lord, I am requesting if my lords can put up this matter in the next circuit, as the arguing counsel is traveling, my lords.
My lord, I'm for the opposite parties, my lord. Private.
Where is Mr. Mitruka?
My lord, he is out of station actually.
Huh?
He is out of station.
He is out of station. All right.
Yes.
On the prayer of the appellant, next available, sir.
Next.
Grateful, grateful.
You are Mr. Mitruka's daughter?
I'm his junior, my lords.
Oh, junior. Okay. Yes.
My lord, item 41, my lord, I am for the appellant in this matter, my lord. My lord, there is a difficulty, my lord. We have filed this appeal challenging an order of the single bench where the board of Waqf has also filed an appeal, but that is before the principal bench. Since the order of the single bench was passed in the principal bench, their contention is it has to be heard in the principal bench. My lord, that matter is fixed before the honorable division bench, my lord, Justice Soman said, my lord. My lord, kindly, my lord, make it.
Let the on the prayer of the appellant, matter is placed before the next available circuit.
I'm grateful to you, Lord.
So you make it for that, the appellant has to make a prayer before the Honorable the Chief Justice.
My lord, that has already been made, my lord. The Honorable Chief Justice has assigned the matter before Justice Sen, my lord. It has to be heard today. It will be heard
All right.
tomorrow.
So
Let's see, my lord, if it is decided, my lord, we'll make appropriate application, my lord.
Huh?
If it is decided that the appeal should be heard before the principal bench, my lord, we'll make appropriate application before the Chief Justice, my lord.
No, you have prayed for this appeal to be placed before the principal bench.
No, my lord, my lord. There was another appeal which is filed by the board.
Counsel for appellant submits appeal arising out of self-same issue is pending before the principal bench.
Okay.
He seeks accommodation to take steps for assignment of this appeal before the principal bench. Let this matter appear in the next available matter. In light of this submission, the matter is adjourned 8 weeks.
My lord, may I make an indulgence, my lord? My lord, kindly don't make this observation assignment because it has to be ascertained whether this appeal will be heard before the principal bench or the circuit bench. That is the question that is to be addressed before the honorable. My lord, kindly adjourn it to the next circuit bench.
Matter is placed before next available circuit on the.
I'm grateful to your lordship. I'm grateful to your lordship.
It's with you. Next. Yes.
This is my application, my lord. There is also delay of 48 days, my lord.
Give note, serve the opposite party.
Already served.
Served. Who is for writ petitioner?
Marada, in this matter, I am for the writ petitioner respondents. Writ petitioner respondent, my lord, just now I have received the brief. Can it be taken up on Monday or Tuesday, any day subject to your lordships? Delay of 48 days is there.
The recruitment for the homeopathic pharmacist.
You reduce the number of vacancies for scheduled castes.
There is a reason, my lord. There is a notification in the initial notification with the as per the 100% roster, my lord, that has not been included. Subsequently, it has been pointed out, my lord. Then with the reason of reducing 32 plus 2, there is an SC disabled categories, my lord. That is the requirement that we have not made in the initial notification. So as per this, the
So out of 30, so
34
the number of scheduled caste candidates remain the same,
same 34
but two of them
are the SC
scheduled
disabled
caste,
categories.
the disability
Yes,
certificate. So number doesn't go down,
No.
only two are from disabled
Categories.
categories. Now, if the two disabled category are not found, then it will revert back to.
Then has to be, my lord.
The selection process has been stalled.
No, everything has been completed.
Huh?
Selection process has been completed.
Appointment letter, my lord, has been issued.
But the
After the selection process over, thereafter they have took steps for rectification. That cannot be.
My lord, this court, even the read court has no jurisdiction, my lord, in view of the section 15 of the Administrative Tribunal Act, my lord. I have a twofold submissions.
But that point was not raised before.
Not raised at any point.
But now I have specifically asked, my ground 7 is one of the, I understand, my lord, the moment it has been placed before me, I have seen that.
If the point of existence of the tribunal is not agitated with the first court, it's the writ court's exercise of jurisdiction.
Point of law, my lord, even any order passed beyond the jurisdiction of your lordship.
No, sir. Article 226 powers are not taken away by the tribunal.
No, not taken away.
All
But
right.
my lord, if it is completely barred by a section 15, my lord, may I hand over the Administrative Act, my lord?
We will consider. You show us one thing, if the issue is not raised before the first.
No, it has not been raised.
Now, first thing is whether the tribunal can take away the jurisdiction altogether of the writ court, or it's an alternative remedy.
It is, my lord, I will say the alternative.
It is in the nature of an alternative remedy.
Alternative, but efficacious.
Efficacious, we will see later on. If it is an alternative remedy and the bar of alternative remedy was not raised before the first court,
Yes.
can it be raised before an appellate court? You don't think so?
My lord, then is a point of law, my lord. Even
Law,
it has not been
correct.
asked, even it has not been.
Law or otherwise, discretionary exercise of powers can be resisted in light of alternative remedy, provided that resistance is taken at the first instance. When a matter has been decided on merits and is traveled to the appellate court, now you cannot non-suit a party on the ground that there was an alternative.
My lord, it is not a non-suiting. They can approach.
Sir,
And it can be.
why should there be an adjudication all over when adjudication has been done on merits and the alternative remedy not agitated? We will not resurrect the ghost of.
I say the twofold, my lord. This is one.
Now, I think
and
the
with
second
regards
fold
to
will be
merit,
better.
my lord, as I will demonstrate, my lord.
Yes, second fold is better.
First
First fold appears to be not very convincing.
Lordship,
So, Section 5 is allowed?
Yes, no problem.
Having
48 days
considered
delay,
the
I have no
government's,
objection.
delay in preparing the appeal is condoned. Matter will appear 1 week hence.
No, my lord, your lordship keep it on Monday so that, or
Not
your
Monday,
lordships,
no,
only
Monday.
one judgment I shall place
Wednesday.
before your lordships can dispose it of.
Wednesday.
Very well.
We are keeping on Wednesday.
Very.
That's what, my lord.
The additional advocacy. All right, Mr. Joyji Chaudhary. We will see on merits what you have got.
Yes, my lord. I have a strong case in merit.
Now, merit you point of the
Yes.
case. Existence of that you could have taken, if you took up
That
the
lot-
point there, we would have agreed.
I-
But
I-
now you cannot take up it. Next,
Grateful.
Mr. Buddy.
Yes, madam.
One authority on alternative remedy must be agitated before.
Very recent Supreme Court, I shall
Very
cite-
recent, very old, we have only one
Whatever,
authority, please bring.
covering all these things,
Yes,
alternative
yes.
remedy is not absolutely bar.
Oh, all that lecture we don't want. Listen to us. The point of alternative remedy must be raised before the trial court.
Yes.
It cannot be raised after a decision has been taken on merits without resistance before the trial court. All right.
There is a continuity of the my lord.
All that
Lordship.
Mr. Joyji Chaudhary, first objection has to be raised in alternative remedy before the trial court, not before the appellate court. Next.
Yes.
কোনটায়? এটা ডিলে কন্ডোল and these next matter. 43.
Matter 43, I appear on behalf of the petitioner, but the restoration application was dismissed. It was not restored.
Very
Learned
good.
single judge was of the view, no. Although my lord, in absence, learned judge observed that he has lost his interest. When I filed an application for restoration, I have the interest, but the my lord, it was not allowed.
Nothing is there. We don't
Your
wish to
lordship.
restore. Next available circuit bench. Nothing is there. What? Transfer
Restore-
order and restored. Wait. Useless.
Next circuit bench. चलो, next circuit bench.
ट्रांसफर हुआ है उसको चैलेंज किया है उसको dismiss कर दिया, उसको restore. By this time you will retire, Mr. Bari. Your client will retire. और कुछ नहीं है. चल. Yes, next matter.
तब पता चले, ठीक है.
44, 45, what is it? Next circuit. Next.
Hello, praying for next second.
Next available circuit.
Defect, do I have to cure my lord?
Defects be cured.
Great.
Available next circuit.
Great.
Next available.
47, my lord, both of us, my lord, we are praying for.
My lord, I appear on behalf of
Tuesday.
my lord, respondent. My lord,
Ah,
my lord, short
yes.
point is involved in this matter. my
Yes,
lord.
Mr. Menon.
Very short point is involved. Whether the applicant is, is entitled to file this appeal. According to me, the appeal is not maintainable.
Kindly
and
text
he is
it
not
about
he
Tuesday.
cannot
I am
be the
led by
agreed
Mr. Basu, Saptangshu Basu, my lord, Tuesday, my lord, kindly.
Tuesday if we can.
He has no locus standi to file this appeal. He had filed an application for addition before
Sir,
the
it
trial
won't
court,
take
which
a
was
lot of
rejected.
time, my lord, a short point, my lord, let us come back on
We'll
Tuesday.
try on Wednesday.
My lord,
Wednesday.
when my lord, Wednesday I have some Tuesday. Can it be on Tuesday? my
Next
lord?
available bench.
No, no, my lord, can it be? My lord,
Menon, all right, Tuesday we keep it, but we'll try. We can't assure you. Tuesday.
very short point involved, my lord. Very
Yes.
short matter. I'm deeply okay.
My lord, item number 48 and 49, I'm only praying for not today, my lord.
Okay. Adjourn for a week. Next available circuit. Same, nobody appears, next available circuit. Same. 50. 50, who is for appellant?
I am the appellant, lordship. I am praying for short adjournment.
Next available circuit. Defects be removed. Next available circuit. 52, who's there?
Lordship, item number 52, Lordship, I am appearing for the petitioner.
Yes.
Lordship, in this matter, Lordship, kindly, I will look on the last order dated 17th November 2023, wherein the state has been directed to file affidavit. No affidavit has been filed up till now.
Mr. Shah, affidavit.
Mr. Saha is appearing in the matter.
So when will you file? Will give you some time? Affidavit in opposition be filed within 2 weeks. Reply 1 week thereafter.
Lordship.
Affidavit appeared 4 weeks hence.
Lordship.
Mr. Shaha seeks further time to file affidavit in opposition. Next. इतना छोटा छोटा है ना, अब बोलेगा प्रिंट आउट करके yes, next.
Yes, 53, this is my application.
For the state, my lord.
Yes.
No, only very short point, my lord. The tribunal did not consider my representation, which was submitted, my lord, before the consent.
Out of time. Out of time.
No, my lord, out of time. No, my lord. Kindly see impugned order, my lord, page 61. And
53.
Delayed.
no, my lord, I made a representation before the authority in the year 2098, thereafter 2000.
Mere making representation does not remedy a situation.
No, my lord, there.
No.
My lord, kindly consider, my lord, one thing.
No, we have considered.
My lord, kindly see.
You have
my lord,
already superannuated.
superannuated because yes, my lord. My lord, kindly see page, my lord, 32, my lord. This is my first representation in December 1998. Thereafter, my lord.
After retirement, you make a application. When the promotion took place?
My lord,
When you were others were promoted?
2000, my lord.
Then in
My lord,
2000.
I have made a representation.
When did you make a representation?
My lord, kindly see page 37. 2000, my lord.
Then thereafter you did not approach the court.
Thereafter,
And then after you retired, you make an application.
No, my lord. Thereafter, my lord.
You demand justice. In
Demand justice,
1696.
2006. That is page 43. My lord, last question, there is a direction to file a report, my lord.
When you were entitled to promotion in 1984.
As per Geo 84.
So you were entitled to promotion on and from 84.
Yes. But in effect from 2000. Kindly see, my lord.
Are they in effect from 2000? When is your first representation?
The first name was 1998, my lord. Page 30 to 33. And 37.
Where is your first representation? State you were supposed to file an affidavit.
Yes, my lord.
Disclosing representation. Can you file an affidavit?
My lord, affidavit is ready, my lord, but since Mr. Pritam Das, he is sick, my lord.
So when?
My lord, kindly.
Keep it next week, my lord.
Wednesday,
Wednesday, my lord.
Wednesday. Affidavit be filed on behalf of the state. Learned Council for State seeks time to file affidavit. Affidavit be filed by the adjourned date. By Monday. By Monday you file the, Tuesday you file the, Monday you file the affidavit. Reply if any by the adjourned date, and we'll keep it, huh? Monday by
My lord,
Monday.
he is on sick leave until and unless he comes.
Who is Pritam Das?
The matter is assigned to him, my lord,
For the state.
for the state, my lord.
Affidavit be filed 2 weeks hence. Time to file affidavit is extended by 2 weeks. Reply 1 week thereafter, 4 weeks.
My lord, Union of India is also a party to it.
I am appearing for I1.
You see,
No role.
no role. You are the, show us whether you received a representation, when you received representation. Just indicate, because he's saying that order says 2013 is the first representation. He says I have made a representation in 2000. He has not, but making of a representation does not entitle an explanation. Representation must be followed by a legal action.
But
the authority concerned to consider my representation.
What consider after 30 years?
No, but that is the 2098, 2000.
Just because of the indolence, they have not filed the affidavit, you survive. Next.
Grateful, Lordship. Lordship, in item number 54, kindly fix the matter, Lordship, not today. Lordship, kindly make it not today. Actually, my affidavit is ready, but by mistakenly, my clerk make it only one set, Lordship.
Who is for petitioner?
Mr. Devanjan Das, I believe, Lordship.
Please inform me, so not this week.
If Lordship keep it in tomorrow, Lordship.
Monday.
Okay, Lordship.
Monday. Next.
55.
Nobody appears for the, nobody appears for the petitioner?
Mr. Onkita, Miss Onkita appears appearing.
Huh?
I'm appealing for the state. I have not received the instruction. Can we take it out before the next one?
On the prayer of the learned lawyer for the state, who is for petitioner? You are for petitioner. What is there in this matter? Huh? Where is the impugned order? Order dated?
Lordship, I am appearing for the petition. I am praying for each certificate.
But Onkita is online. Wait for next cycle.
Next
I'm praying
available
for next
certificate. Next.
56.
Lord, I am appearing in behalf of the petitioners.
Yes.
One of the petitioners, one of the employee of the police constable, and termination order was passed. In 2007, kindly see page 21. Page 21, kindly 5th paragraph. 21, first, second, 5th paragraph. File and other relevant records, it appears from the criminal case started against him, ended in charge sheet and under trial in the concerned court, Jalpaiguri, such and such. Subsequently appears from the opinion of the government pleader in writing, the authority concerned to apply the principal mine, and it would be appropriate to follow the same line of action, hence applying mine objectively and judicially. The final order of the instant proceeding kept abeyance till the judgment of the criminal case passed. The disciplinary authority, without there is no independent findings. Only the criminal court. If the criminal court they held guilty, then they will take steps. Well, the
Yes.
ultimately criminal court convicted me as such, well, terminate my service. Well, page 22, well, kindly see. After
Very
careful consideration, evidence on
Very
record and
correct decision. Very correct decision.
now then, my lord, the appeal court, my lord, the Honorable High Court, my lord, acquitted me.
Acquitted you.
Or page.
All right. Now the disciplinary proceeding can start afresh.
Ordering portion, my lord, page 45. Ordering portion, page 45, my lord, the Honorable High Court, my lord, acquitted me.
Yes, so the matter was referred to the authorities for taking a decision in the light of acquittal.
Acquittal, my lord, page 73, my lord, kindly see the authorities, my lord, observations.
Let us see.
Page 72, my lord, 72, paragraph 6. My lord, the stated position of the Honorable Supreme Court of India on the issue is a very clear that the acquittal of an employee by a criminal court would not automatically and conclusively impact departmental proceeding.
So,
Firstly, but department, if authority, my lord, already accepted that if the criminal court decision, they will take in. But they will take a decision as per the criminal courts, but there is no independent finding.
thereafter,
Thereafter, my lord, page 73, my lord, in a paragraph 7, last, my lord, of four or five lines, my lord. He was acquitted of the Honorable Court Investigation Agency, but this is not in Lord, the acquittal by the Honorable High Court. Honorable High Courts, Lord, specifically observed, Lord, there is no such appreciation, there is no such evidence against the petitioner. Lord, kindly see the investigation agency charge level against last 4 or 5 lines. The charge level against him over the same was proved in a full during the departmental inquiry. During the inquiry, he was placed under suspension, which was confirmed during the final order. Also, the dismiss of the discipline authority with effect from such and such. Then, my lord, finally, my lord, the page 74. My lord, page.
so you were reinstated.
Reinstated with break service, my lord, and without giving any, my lord, back wages.
Right.
And petitioner already retired from service, my lord. As per the break of service, my lord, the petitioner is not entitled to get pension also. Pension and all the other retirement benefit.
Right. Then what happened to the tribunal? Tribunal, what did the tribunal hold?
Tribunal, initially, page 85, tribunal get a findings 85 and 86, then last order, tribunal referred the matter to the division bench of that tribunal, up to since 3 years, there was no division bench in the tribunal.
Then what happened?
Last page, the tribunal referred the matter to the division bench because this matter relating to back wages.
So there is no decision by the tribunal. What will we do?
It is pending, my lord.
The tribunal, there is there is no division bench. There is no division bench, Tribunal, there is the division bench since 3 years.
What happens? There is no division bench. What will you do? But this application.
Lord, he
There
was
is-
convicted.
So we understand everything. The limited point on which we will be considering is he will not get back wages. But so far as his continuity in service,
He has been reinstated and he's.
listen to us. He has been reinstated from the day on which he was acquitted. So instead of doing that, the period for his suspension has not been treated as on duty. We would like to examine that issue, whether he may be treated as on duty. But more importantly, when the tribunal is vacant, whether this court can entertain directly an application on proceedings under Article 226.
Lord, it is not in my knowledge, but the court is vacant or not, that I don't know, but the matter is pending before the SAP.
So, give us intimation. He says that the tribunal does not have sufficient quorum to hear the matter. If that is so, then we will invoke our jurisdiction Article 226 that a person cannot be kept remediless because of absence of a forum.
Lord, in that case, then we come back with further instruction, Lord.
Because the last order on 8/2/2024 relates to disciplinary payment of gratuity involved point, and therefore it would be heard by a bench comprising of 2 members. Let the matter be played before such a bench comprising of 2 members. Is there a bench?
Lord, we'll have to take
Please
instruction.
clarify that position. Learned counsel for petitioner submits that the case was referred to a bench comprising of 2 members, judicial and administrative, by a single member of the tribunal. The tribunal does not have requisite quorum to constitute the bench. Hence, he has approached this court for relief. Learned counsel for state shall submit report with regard to the availability of bench comprising of the bench concerned. Shall file a report with regard to availability of the bench comprising of 2 members on the adjourned date. Matter will appear before the next available circuit. Acquittal होगा. But it is acquittal or that is 306 का case. Where department of this? Oh, dismissed because he was convicted. He has been acquitted, so he has been reinstated. Now he has been reinstated from the day he was acquitted, right? So that period should be treated on duty notionally without any back wages for the purpose of pension and retirement benefits. Bas. Next. All right, nobody appears for the petitioner. Next available circular.
Here, 57 is safe, 56 and 57 safe. Sorry.
56, 57 same means?
Same. 56 milord, Kaushik Chatterjee's appeal.
Where is Kaushik, sir?
55 and 56 and 50.
56, where you dismissed because of, then
And 57 same.
how can it be same matter? You know what is 56? What departmental proceedings? Were you convicted and acquitted?
Yes.
All right, same order.
Two person convicted, well, they are
306. 306, okay. Same order. Find out whether the quorum is there. Tribunal. If not, then we'll resume jurisdiction and pass appropriate orders. Please produce a judgment that if the there is no member in the tribunal, the court will assume jurisdiction on Article 12.
But 57 was same matter, my lord.
Yes, all right. Next matter.
Same matter.
58, Mr. Mujumdar.
We are the appellant.
Yes, what do you say?
My lord, it's a appeal against an order passed by the tribunal.
Right.
My lord, certain persons were appointed as Gramin Dak Sevak. Subsequently,
Then what has happened?
My lord, subsequently, vigilance found out the entire selection proceeded to be.
No. Thereafter, respondent is not there.
No, my lord.
Then?
My lord, but we are facing a contempt before the cat.
There is an assurance that contempt will not be pursued.
My lord, kindly states that.
Let us give 1 day notice.
So he appeared.
Yes, lawyer appeared. Give a notice to the lawyer. Not this week.
Petition, my lord, I think my learned friend wants to say that there is a word in the earlier order that writ petitioner was mentioned. That is creating confusion.
All right. The word writ petitioner in order dated 11/12/2003 be read as respondent number 1. Respondents, how many respondents?
Only one.
Acha. Respondent / applicant before the tribunal.
That's my lord.
Let the matter appear before the next available. Next. Huh?
Number 6. Kindly come to the order dated passed by the order passed by the respond number 6 taken an application formula compaction and abandonment. Applicant with your lordship, similar the father-in-law. Father-in-law.
Where are the private respondents? Where is the applicant? You are the applicant. Huh? You are the.
I am not the, Mr. Shankar Pal is the advocate for them.
First thing, who is for Kodobirai?
I am the respondent.
You are for Kodobirai. So you are for the applicant before the tribunal and respondents here. Now who is for Baswanti Rai?
Mr. Shankar Pal, he is for the bus.
So what do you say?
So I am praying for only next circuit. He is before the.
No next circuit. No next circuit.
Then Lord, you kindly fix it.
It's a direction for consideration of a representation. Why this should remain?
Representation already considered. That has been considered. Kindly come 121, page number 1.
This order already acted upon.
Yes, 121.
121.
Yes, sir. Annexure 3A.
Order dated so and so, challenged in the writ proceedings. Order dated so and so, by order dated 1/12/2023, the tribunal had directed respondent railway authorities to take a decision with regard to the prayer of the respondent number 3 wife for compassionate appointment and release of pensionary benefits to compassionate appointment and release of half of the death service benefits on the account of death of her husband. Full stop. By order dated 14/3/2024. Now this order has been impugned by the writ petitioner, mother. Writ petitioner.
The petitioner is the mother-in-law died in the meantime.
This order has been impugned by the who are these petitioners?
Father-in-law. Father-in-law of the respondent.
Number of them are there. Everyone is father-in-law. Strange. By the father, and who are the others?
Son.
Father and son of the deceased employee, representing son and daughter of the brothers and sisters of the father and other, and the brother/sister of the deceased employee. Full stop. We note that the order impugned has already been given effect to, and the respondent who has passed the order. Respond number?
Divisional personal officer.
Divisional personal. Senior Divisional Personnel Officer. Respond number 4 has passed a reasoned order. Full stop. In view of the aforesaid fact, nothing remains in the writ petition. Writ petition is accordingly dismissed. Nothing remains to be decided in the writ petition. Writ petition is accordingly dismissed. It is open to the petitioners to challenge. It is open to the petitioners to challenge the order passed by respondent number 4 in accordance with law, if so advised. Name him.
I'm appealing for the respondents, my lord.
Who is for petitioner? Next available, sir.
This has been running since long. The prayer is an innocuous. It's for expeditious disposal of the OA pending before the Land Reforms and Tenancy Tribunal.
Nobody is appearing. What can we do?
As you.
Let's do like today it's 4 PM. We can dismiss it for default.
Yes, ma'am.
Dismiss for default.
Yes. Same. The issue is different though. Here the order was passed and challenging that order, this petitioner.
So this is something.
Yes, but this has to be decided on merits.
That's what we are saying.
Yes.
Not this week.
Lordship.
Next.
Did you want to not be?
62.
62, I am for the respondent number 4.
And I'm for the petitioner.
I am for the respondent number 4, the original applicant before the tribunal.
Lord, the facts of this matter is, my lord, an order passed by the LRTT of status quo, my lord, in an utterly perverse order without any application of mind is, my lord, assailed before your lordships. My lord, I'll straight away take your lordships.
We direct the LRTT to dispose of the main OA.
Yes,
I am aggrieved by the order of status quo. Because, my lord, LRTT at first, even if it passes an order of injunction, the injunction order has to go through the parameters of, my lord, order 39 of the CPC. That is settled. Now, my lord, kindly comes to the order impute. My lord, the relevant part is at page 24. I have annexed the order as well as an annexure. Kindly comes to page 24 of the, my lord, petition. Now, Lord, this page 24 is where the LRTT records its satisfaction. It says, my lord, on perusal of the same, we find that 2 civil suits are pending before the Honored Civil Judge, Senior Division at Jalpaiguri, TS 55 and TS 209, challenging the validity of the deed in question. If that is the position, then a status quo must be passed. Now, my lord, this recording of this satisfaction is, my lord, illegal.
What?
My lord, I'll place a very recent. I'll not trouble your lordships with many judgments, but I'll place a very recent full bench judgment of the Supreme Court, where it says, my lord, that before passing any order of injunction, the 3 parameters of passing an injunction order has to be, my lord, ascertained, which is, my lord, the prima facie case, the balance of convenience and inconvenience, and, my lord, the irreparable loss and injury. Now, my lord, in that regard, I'll again point out, my lord, the reference of the suits that are here. These suits, my lord, have been filed by the petitioner. If at all any injury would be caused because of these suits, and, my lord, because of this order of status quo, it would be, my lord, to the petitioner, not to the, my lord, opposite parties. These suits have been filed by me against them, and that has been made the basis of passing an order of status quo. My lord, kindly seize this judgment once.
Referenced. Referenced.
What are these civil suits about?
My lord, declaration of my title and injunction against the, my lord, opposite parties. Now, my lord, if I may come to the declaration of my title with regard to the suit line.
So you filed the suits?
Yes, my lord. I have.
You have filed this.
Against the predecessors in interest of the opposite parties,
And
as well as my lord, the
who are
opposite
the
parties.
petitioners before the tribunal?
Before the tribunal, my lord, the defendants of this suit.
Who are the, what is their
Now, my lord,
right
I'll
and-
come to the then factual aspect of this case.
What their
Now, my
right?
lord,
They purchased the land from
what has
someone?
happened, my lord? My chain of title goes up to the my lord R.S. Khatian. My chain of title is perfectly clear. Now, my lord, in the year 2021, the my lord legal heirs of one of the owners in between, my lord, happened to my lord cheat the opposite parties and sold them off the land which was already sold off by their predecessor in interest in favor of my lord my predecessors in interest. That is my lord the factual aspect. Now, my lord, Ardhendu Shekhar Lahiri was my lord the recorded owner of R.S. Khatian 20/2. Subsequently, my lord, Ardhendu Shekhar Lahiri sold off 8 katas of land to my lord one Shamal Kumar Kundu. Now, my lord, Shamal Kumar Kundu thereafter sold off the land to Narbada Chetri and Meena Adhikari. And thereafter, my lord, Meena Adhikari and Narbada Chetri sold off the land to Gopal Chetri. And my lord, Gopal Chetri sold off the land to my lord, my clients, the petitioners hereof. Now, my lord, in 2021, the legal heirs of this Shamal Kumar Kundu, who happened to sell off his entire property within the subject plots in the year, my lord, 1978, sold off some portion of the land to, my lord, the opposite parties. Now, my lord, they, on the basis of those title deeds, they, my lord, got their name recorded in the LR Khatian. Now, my lord, in the year 2021, we approached the my lord BLRO for correction of our records. Now, my lord, will find the order of the BLRO at my lord page 71. Now, my lord, the BLRO, after giving them a detailed hearing through a reasoned order, my lord corrected the records, and my lord the records were stood corrected in our name. Now, my lord, against that order, they approached the DLRO. The DLRO again, after hearing all the parties concerned,
Affirmed the order.
affirmed the order. Against that, my lord, they have approached the LRTT.
You are in possession of the land.
I am in possession, my lord. I am running a car wash on the land. This is where, my lord, my grievance comes. Because after passing of this order of status quo, they, my lord, filed apparently approached the police officers. Now, the police officers, my lord, are my lord,
Will
frequently
clarify that
harassing.
you are in possession of the land.
And my lord, the matter may be remanded back to the LRTT for fresh hearing.
Finally, you dispose of the
Yes, my lord, but the status quo needs to be set aside.
status quo needs to be explained that you are in the possession of the land.
Yes.
But yes, Mr. Bhattacharya, they are in
No,
possession.
they are not in possession. That's why they are scared of status quo.
All right,
So
we'll
how could the
vacate
revenue
status quo
officer
then.
decide the title? When
All right, we'll vacate the status quo then. We'll say that any action will abide by the result of the application.
No, that would not create that would create.
Let it create.
because for the
Mr. Bhattacharya, let it create havoc. Let it create havoc.
Because the havoc is
But
created.
you are unfortunately trying to eat the fruit of the poisonous tree. Your title no longer exists. So
No, my title exists. Because the declaration filed in this suit, they could not get an injunction, but the revenue officer decided the title.
Because, my lord, a caveat was this.
While the civil
Which is
suit
why,
is
my lord, we
pending.
could not get an
Kindly
injunction.
what
see the order.
injunction will they get? What
My lord?
injunction they will get? They have asked, they are in possession, according to them. So they have not asked for recovery of possession. They have only asked for setting aside of the deed. That is the final relief. What injunction do they get now?
Milord, they have filed a suit seeking the declaration of title. Because while the declaration of title was pending, the civil court did not grant them an interim order. Now they go for the revenue officer. The revenue officer decides the title without looking into that pendants of suit. That's why the tribunal says that the status quo as of date without changing the character should be maintained. But this order does not affect anybody. Except that, Lord,
It does, my lord. My legal notice, my
on the
lord,
basis of
is at page 84.
on the basis of failure to get order from the civil court, now they get it to revenue officer. It's quite surprising. Has the revenue officer jurisdiction decide title when the suit is pending? Kindly come to the page 101. Only the effective order which requires the tribunal should decide the matter as early as possible on merit. No question of interference at this stage. This an in-
What interim order will be passed? They ask for declaration.
Kindly come to page 101. This is the prayer made in the suit. The suit will not, their prayer is declaration of title and injunction that they failed. Now then they go before the revenue officer. Revenue officer declares the title.
That is a separate forum under the Land Reforms Act.
Okay.
That is my right, man, to get the
Revenue
records
officer,
correct.
with the best of expert, cannot decide title when the title is pending. That's why the tribunal says. That's why the tribunal says they let the status quo maintained. Revenue officer has decided the title. Kindly come to page.
Will we
107.
remand this matter for fresh consideration
Yes,
by
yes.
the tribunal?
Kindly do this.
Will vacate this interim order. This
Your
interim
Lordship,
order is in violation of the principles laid down for recording an order of status quo. First defect, the tribunal does not state who is in possession. Without
No, but
doing that, the tribunal could not have passed a status quo.
No,
with
I do
the
appreciate,
possession.
but look, kindly see tribunal.
So we will remand this matter. At best, we can remand it for fresh consideration. Or
That will not
alternatively, we'll vacate this order and ask the final order to be passed by the tribunal at the earliest.
But in the meantime, Lord, if they change the nature and character,
Whatever they do,
Then-
all
then-
will abide by the result of the OA. Nature and character all will be decided in the civil suit.
Civil.
therefore
Not
the nature and character we maintain
Yes,
as it is
nature
today.
and character, why should the tribunal go into it? Civil suit is pending. Parties
That's
are at
why-
liberty to take appropriate
on the same
injunction in the
principle-
civil court.
Look,
But-
that's the position. Look, how could the revenue officer do it? My lord is
That's
absolutely right.
exactly what we also feel. That
Therefore,
if
that
you
order
didn't
be
get
set
a
aside.
status quo, why you will get a status quo?
Therefore, Lord, you can set aside the order of the revenue officer. I don't mind.
Yeah, we will set aside the order of the tribunal. The revenue officer will be decided by the tribunal later on.
No, like if the
Take down.
revenue officer will not decide the title.
Order dated 10/1/2024 passed by West Bengal Land Reforms Tenancy Tribunal granting an injunction in
Not
the
injunction,
nature of
maintaining
status
status
quo
No.
in respect of nature, character, and possession of suit property, and no third party interest over the suit property.
My title.
Is under challenge. Petitioner submits he is the lawful owner of the property in question. He is the lawful owner of the property in question. Full stop. Full stop. Predecessor in interest. Your predecessor in interest purchased the property.
Yes, my my chain is, my lord. I am currently the owner of the property. The last deed was, my lord, executed in my favor.
It's not the issue, which they have said in the civil suit.
Civil suit, what is it? Is
Not the
My
civil-
lord,
one.
my lord, you'll find the plain at page 46.
One Shamol Kumar Kundu.
Only
One
will not
Shamol
be
Kumar
confined to the
Kundu.
schedule mentioned.
Correct. One Shamol Kumar Kundu, since deceased, was the recorded owner in respect of the property in question. He executed a deed. He transferred the property in one Shamol Kumar Kundu, since deceased.
My lord, if my lord sees the list of dates, my lord will find.
Where
the-
is list of dates?
This, my lord, clarifies the.
Well, I am the purchaser from the sons of the Shamal Kundu. My right also is
Or
there.
then do and others.
And we are the purchaser from all the do.
They are the purchasers from, my lord, legal heirs of Shamal Kundu.
Then and Nobendu Kumar Kundu. They are my vendors. They are the sons of Shamal Kumar. Yes. We have purchased from Shamal Kundu's heirs. Anup and Navin. These are all in the civil code. Our deed is 2021. We are recorded on me. He record
One Shamul Kundu, since in 1978, Shamul Kundu, since deceased, had sold the property, had sold land measuring 8 katas in favor of Narbada Chetri and Meena Odhikari Vide through 2 registered sale deeds. Full stop. Said Narmada Chetri and Meena Odhikari transferred 4 katas out of 8 katas in favor of Gopal Chetri.
Not 4 katas each, altogether measuring 8 katas.
Transferred the land in favor of Gopal Chetri through Vide 2 deeds of sale, 2 registered deeds of sale. Gopal Chetri in turn sold Gopal Chetri, thereby Gopal Chetri, he had 2 katas, 2 kata 8 chata.
10 katas, 8 chatas.
10 katas, so he had 2 katas independent of
Yes,
that.
Prior that explanation is there,
Prior to the sale, Gopal Chetri was owner of 2 katas and 8 chataks in the property. Gopal transferred his entire land comprising of 10 katas, 8 chatak in favor of the petitioner and his wife Parvati Devi by 2 registered deeds of sale in 1994. Petitioner and his wife, since then petitioner and his wife are in possession of the said land.
C0 line হচ্ছে ছিদুরের ভেতরে আছে, that is an acquired land. ওদের এখানে লাগিয়েছে C0 line is রাস্তা ভারত সরকারের জমির তালিকা, acquired land, that is why that's the point. ওরা acquired land কিনেছে, কেনার পরে এখন আমাদের দিকে ঢোকার চেষ্টা করছে।
Now, who are the respondents here?
Respondents are
Vinod Jaswal.
Yes.
Kindly come to paragraph 12 and 13 of the plain. It will be clear that they were not in possession, and that's why they asked for injunction against us.
No, they are in possession. They are saying that they should not be disturbed.
No, they say that the petitioners, my lord, had already entered into the land. They complained to the police.
Yes, so
therefore, we have entered. We are in possession, physical possession. They are not. Making up the story. The civil court has not. They are on, my lord, on symbolic possession, and this injunction was refused by the civil court. How could the revenue court grant it? After going into everything, order 39 rejected. They have not annexed everything. We'll everything on record. Order 39 prayer was rejected, giving reasons.
Not going to a caveat that was. I have annexed your entire order sheet.
We are not understanding. Where have you stated that you are in possession? Where have you stated that you are in possession?
The order of the DLR as well as the DLR, my lord.
No, that order of DLR, in the civil suit, where have you stated?
My lord, I'll come to that.
Now, and Vinod Jaswal, he got property from where?
He bought the property from my lord, sons of Shamal Kumar.
When?
My lord, in the year 2021.
In 2021, sons of Shamal Kumar, sons of Shamal Kumar Kundu illegally transferred a portion of the land in favor of respondent, in favor of, and who is this Ram Shankar Singh?
Ram Shankar Singh is my lord, the petitioner.
But you are
Ram Shankar Singh and Parvati Devi, my lord.
Huh? Oh, you, petitioner,
yes.
wife is
Parvati Devi.
in favor of respondent number 4, full stop. Under such circumstances, petitioner filed title suits praying for declaration of title and permanent injunction against the said said fourth respondent Vishal Jaiswal. Vinod Kumar Jaiswal.
Second suit. There are two suits, different set of persons.
Against Vinod Kumar Jaiswal.
And my lord,
TS suit number 209. And who is this Anupam Kundu?
my lord, sons of Shamal Kumar.
Sons of Shamal Kundu. My vendors.
Against the purchaser as well as the sons of Shamul Kumar Kundu. Full stop. The suits during the pendency of the in the meantime, Vinod Kumar Jaiswal had entered his name in the records of rights before the DLLR. Petitioner applied for rectification of the records and the records were rectified. In appeal, the order was confirmed. This was carried by respondent 4. This was challenged by respondent number 4 before the tribunal in OA. The tribunal, without recording its satisfaction with regard to a prima facie case in favor of Vinod Jaiswal and mechanically passed an order of status quo in respect of nature, character, and possession of the suit. Full stop. According, he contends that the order of vacated. Mr. Bhattacharya, senior advocate, submits respond number 4 is respond number 4 is the owner of the land in question. The deeds have not been cancelled by the civil court. Property dispute being with regard to immovable property, the tribunal suits in question. Stop. Petitioner is not petitioner and his wife is not in possession of the property and failed to obtain an injunction against the petition against the fourth respondent in the suit proceedings. Full stop. Accordingly, hence the order of status quo. In the event the order of status quo is vacated, he would enter into possession, and this would give rise to multiplicity in proceedings. Full stop. In response, petitioner is emphatically submits that he is in possession of the premises and refers to.
But with regard to the plot number 309, that is the claim of the petitioners. Which is a vested land. Plot number 309.
Vested, not vested, they will be decided finally. As of now, it is in possession.
No, that is in the revenue report.
Where have you said you are in possession?
Kindly comes to page 50 of the petition. In the civil suit, my lord.
Petitioner emphatically submits they are in possession of the land.
Nowhere they are stated.
My lord, para 19 onwards. Para 19 onwards, my lord, clarifies the state of events.
Paragraph 19 is very clear that they are not in possession.
My understanding, my lord, this is clear that they're trying to enter forcibly into possession.
So they are trying to enter forcibly into possession does not mean that you are in
You are in
possession.
possession.
My lord, I'm
Who
running
is
a,
in possession?
my lord, I'm
You have
running a
never
car wash.
stated in your petition that I am in possession of the land and they are entering and trying to dispossess me.
My lord, in any correction, record correction proceeding, my lord, without clarifying the possession of the property, my lord, the BLR or the DLR could not have passed an order of correction.
Where
in
is
my
the
favor.
BLLR saying that you are in possession?
Taylor was assumed jurisdiction illegally. Yes, he decided the title suit. Taylor order.
Lord, page 71.
Taylor order. Page 61. Taylor order. Last order. The challenge people be tried. No, again, BLR to that. Which photo? 61. 61. There is an application for mutation only. It is without giving opportunity.
Lord, page 70.
There is application mutation. The other to mutation could like. Seventy is an affidavit.
They are party. Absolutely.
Nothing has been.
They can't. There is nothing that you are in possession. Children, learned lawyer for the emphatically disputes, emphatically reiterates that they are in possession of the property. We have considered the rivals, we have perused the order of injunction. The order merely records 2 civil suits have been instituted by the petitioner. 2 civil suits being PS number so and so has been instituted by the petitioner, challenging the validity of the deed of the 4th respondent. Full stop. The tribunal does not make any finding, does not record any finding with regard to the possession, with regard to the possession of the applicant, with regard to the possession either of the petitioner or the 4th respondent in the suit property. Nothing is suit property. It also did not advert to the fact that the authorities, that the BLLRO and DLLRO had come to a concurrent finding that the deeds of the 4th respondent, that the deeds executed in favor of the 4th respondent were deeds in favor of the 4th respondent were executed after where in latter point of time than that of the petition. Full stop. There is in this view of the under such circumstances, the order granting injunction in the form of status quo suffers from suffers from patent illegality and material irregularity. Accordingly, the order is set aside. The matter is remanded before the to consider the prayer for prayer for injunction afresh after adverting to the the existence of a prima facie case in favor of the fourth respondent and after adverting to the existence of a prima facie case in favor of the fourth respondent and finding vis-a-vis, and if such prima facie case exists, a finding vis-a-vis, a prima facie finding vis-a-vis possession of the land in question, full stop. The tribunal shall take decision in the matter within 2 weeks from date of communication of this order after giving opportunity of hearing to both the parties.
But one shall establish, but in the meantime, the nature and character, if it is destroyed, the nothing remains. Kindly ensure that the nature and character is not disturbed.
Next. Disposed of. Okay. You please give that authority of